All right, good morning, everyone. Great. We are live streaming this morning so that you all know. If you're here, defendants, please rise and so that we can identify you. I don't have my list. Yeah. Okay. Do you have? Do you have jury announcement?
I do.
Just three, right?
He's got it.
Yes. All right. If I call your name, please. Oh, you can be seated now. I meant when you call your name. I apologize. Just let us know. And attorneys, if you have a quick announcement, you can make that. But out of respect to your colleagues, let's not make it too long. Nicholas Acuna. Samuel Ariola. Joe Cappuccino.
President Council, Your Honor.
Very good. I'll mark you conferring.
Thanks.
Priscilla Cordova. Josue Crespin Efegenio. Morgan Dickerson.
Judge, his family hired me from Brown yesterday. She's downstairs talking to him.
Okay, very well. Do we let the other attorneys know?
Yes.
Thank you. Jose Duran. Elijah Ellaby. Daryl Ellison. Luis Angel. Thank you, sir. Cecilio Fabian. Francisco Flores.
Here you are.
Thank you, sir. Tommy Garcia.
Present.
Thank you, sir. Brendan Garcia Ramirez.
Here with counsel, Your Honor, we're going to be asking for a resettlement. It's a motion to revoke. I've spoken to the state. This is my first appearance. I just got hired Friday.
Okay, we'll you can be first and we'll discuss it.
Thank you.
Thank you. Frank Hernandez.
Here you are.
Thank you, sir. Patrick Jones.
He's present with counsel, Judge. I was just retained and had a order sub-signed. I talked to the state. I'm still waiting on discovery, so we'll be asking for a reset.
Okay, we'll come forward on it and you can be the second one.
Okay, thank you.
Cassie Lately. Garen Magistro.
President Council, Your Honor, I spoke to the state. We'll be asking for a recess today.
Okay, let's approach. Y'all can be third. Jabari McGilvery. Roman McKibben.
President Council, Your Honor, same thing. Spoken to council. We'll get to the state. We'll be asking for a recess today.
Okay. We'll discuss. Robin Medina.
Judge, I gave a waiver to this one.
Okay, that waiver is signed. Alexander Mikhailowicz.
President Council, Your Honor.
Okay.
Please mark this. Conferring.
Conferring. Very good. Thank you both.
Thank you.
I don't have you listed on here. Have you made a new announcement of attorney of record?
New one, no.
Okay. I don't. Did you withdraw after we finished the last case?
Not formally, no, sir.
We don't have to do it here in front of everyone, but let's just make sure that we've got you down on the system. Okay. Thank you. Gilbert Maureen.
President Council, Judge, if you got a recall, please.
Yes, sir. I'll mark you confirmed. Thank you. Jose Palacios. Thank you, sir. Oscar Pastrana. Nathaniel Ramirez.
I just want to go on the phone to the parking lot. It should be up shortly.
Okay, please let us know. Jesus Renteria Rios. Jasmine Richard. Thank you, ma'am. Augustine Schulke. Eric Sundin.
President, Council, Your Honor, spoke to the state, we'll be requesting a reset.
Okay. Get them all together and let's approach.
Thank you.
Paul Tompkins. Brandon Vasquez.
President, Council, Your Honor, we've got an offer where it's gonna require me to do some things up front, so we're gonna be asking for a reason.
Okay, come on up. Unique Walker. And Miles Williams. All right. Do you have that announcement? Or did you find it? The announcement, Docket. He gave me the non-announcement. All right, on the announcement docket, we have Josh King.
State's ready. Can we approach the call the docket?
You can. That's fine. We'll discuss it. Ray Signs.
State's ready.
Thank you, State. Michael Spear.
President, Council, Judge, we're not ready.
Okay, we'll approach and discuss. All right, you can continue to confer, and anyone who's ready, come on up. Tell me your client's name, please.
My name is Bobby Taylor.
No, I know who you are.
represent
I know who you are, Bobby. I'm saying your client's name.
Brandon
Quiet,
Garcia,
please.
Brandon David Garcia Ramirez. Motion to revoke.
Quiet, please.
Garcia Ramirez, please approach.
I just got hired on Friday. I'm gonna be representing him. This is alleging that some things occurred while on probation, so I just got the motion to revoke paperwork. It alleges a matter that occurred in Austin. I represent in the Austin matter.
Very good. Have you all conferred?
No, I just came in this morning. Yes, I talked to them this morning about it.
Okay.
We haven't tried to negotiate or work anything out. I just picked up the copies of the complaint and what's violations. And so I'm gonna talk to them and we can work something out.
Okay, very good. We'll set it for a contested hearing in 30 days, but if you have something worked out before then, we'll be,
It's not gonna be a contested matter.
Okay. I just have to have it set so that we're ready and no one's surprised, the state can get their witnesses. But let's come back in 15 days then on just a setting where you let me know if you want that. But I have to give the state enough time to get their
I don't
witnesses.
dispute, I understand, and I'm agreeable with it. I'm just saying, we will not be contesting
Okay.
the allegations.
Okay.
It's just a matter of trying to.
Quiet, please.
Sort out what's
Yes,
the next
we're
step.
not gonna be contesting the
Okay.
allegations. It's just a matter of what are the options and what can we do?
Very good.
You know, I left my docket back to my calendar back here, but I hope the date you're looking at is not September 11th through the 21st, because I'll be on vacation.
Well, good for you. I hope you're going somewhere good. We all we can discuss it with Becky and figure out the good day.
Thank you, Judge.
Thank you.
May I approach? Your
Yes.
Honor? Patrick Jones.
Quiet,
Mr.
please.
Jones,
He's-
Mr. Jones, come on up.
Sorry, Mr. Pennington.
Yes.
Yes, sir.
Good morning.
Good
Thanks for
morning,
being
sir.
here.
Yes, sir.
So this is a case where I just substituted in, maybe within the last 2 weeks. I submitted a discovery request last week. I haven't received any discovery on the case. This is his first non-arraignment setting.
Okay.
So I just need time to,
No problem. State, what's the status of discovery?
Judge, I believe we just received his request for it, and I'm going to have an agreed protective order I would ask defense counsel to sign so that we can provide him with copies of the CPS records, as they are quite extensive, and it would be very difficult for him to review them at our office.
and I have no objection to that.
Okay, we all just keep conferring. State, do you have an offer?
I do not have an offer yet, Judge. I am still in the process of reviewing about, I think, 10,000 pages of CPS records.
Okay, all right, we'll do a regular reset. Thank
Okay.
you both. Feel
Thank
free
you,
to go
sir.
about your business after you get your reset.
Yes, sir.
Thank you. Carlos, who do you have today?
Vasquez, it's Brandon Vasquez.
Brandon Vasquez, you want to come on up, please? Morning, sir. This is really good USA soccer player.
Brandon?
Named Brandon Bosco.
Yeah.
Do you know? Do you get the
I've heard of
recipient?
him, yeah.
For being here on time. All right, what's the status here of this case?
Your Honor, we just received an offer early this morning before court, and it has some stuff that he's gonna be required to do before that offer gets formally put in writing.
Okay.
And we just asked reset for him to be able to start working on the things he's gotta do.
Very good. So it sounds like your attorney's been talking to the state, working things out for you. Make sure if there's information that is being requested from you, that you get that to him, okay? Because we don't want that to be a delay for the state finding out information that can be helpful to your case, all right? So but that's on you. It can't be on your attorney, all right? Do you have discovery?
Yes, I do.
All right. We'll do another pre-trial reset. Thank you for
Okay,
being
thank
here.
you.
Thank you, sir.
No, get right.
Yes, of course. Who do we want to do first?
Let's do Eric Sunday.
Eric, can you come up, please? Morning, sir. Thank you for being here on time. Last time we were here, you went to get an attorney, and you did that. Good job. Thank you. Do you have discovery on this case?
I have most of the discovery. There seems to be some discovery that's missing. We've asked the state to look into that.
Okay. State, what's the status?
There were some written statements that were not originally provided by the law enforcement agency. We are inquiring about those.
What's your timeline in getting it to the defense?
I would hope we would be able to have that to him within 2 weeks.
Very good. And do you have an offer?
We've received an offer. Yes, Your Honor.
All right, anything else we need to take up?
Not at this moment, Your
All
Honor.
right, thank you, sir. After you get your reset, you're free to go about your business. Okay. But just wait for that reset. Thank you. Next,
Roman McKibben?
Roman
McKibben?
McKibben.
Yes, MCK.
Mr. McKibben, can you approach, please?
It was a good day.
Morning, sir.
Morning, sir.
Thank you for being here on time.
Of course.
All right, do you have discovery in this case?
Yes, Your Honor. And we received an offer today. Just need some more time for, I believe, clients working on a mitigation packet and for us to continue to negotiate with the state.
Very good. Sounds like your attorney's working for you, talking to the state. He said he needed a mitigation packet, so make sure that if he's requesting information for you, that you get that to him. Because it can't be on him, it's now in your hands. Make sense? Yes, sir. All right, thank you very much. After you get your reset, you're free to go about your business. Thank you. And the next one?
Garen Magistro. Yes.
Mr. Magistro? Hello, sir. I think last time we were here, we discussed you needing to get an attorney, and you did that, so thank you very much. And thank you for being here on time. Do you have discovery?
We've received the discovery. I've reviewed the discovery. I still need to discuss discovery with the client.
Okay.
We've also received an offer today.
Very good. All right, we will reset that case for another pre-trial. After you've received your reset notice, you're free to go about your business. All right, make sure you're taking care of things out there and follow your bond conditions. Thank you.
Thank you, Your Honor.
Thank you.
May I be excused?
Yes, you may. Yes. Okay, Mr. King, can you approach, please? Sorry, Joshua King, yes. All right, we're set for a trial today. State,
State's ready.
defense,
Your Honor, we are ready. However, we have an issue that's came up with regards to two witnesses
that were previously unserved at the last sitting. We have served them, once in Midland, once a former law enforcement officer. Both of those witnesses were subpoenaed. The subpoenas were served. They should have been filed. If not, I have the original copies also. They were both subpoenaed to be here today at 9 a.m., Your Honor, because we figured it might be a problem that if we did it on Monday, that they might not show up and we'd be in this position. So since they're not here, Your Honor, we're gonna be filing a writ of attachment, Your Honor.
Okay.
And we're hoping that that's served by Monday and they're either taken into custody to post bail to be here for us, Judge. They're both critical to our case.
Have you had contact with them?
Your Honor, the only contact, I've emailed, I called, I've left messages, no contacts. However, they were properly served, Your Honor.
Okay, well, let's get together all that information. I'll take a look at your motion for the attachment and we can discuss it.
Okay.
Do you have that filed yet? or
I
you
have the
ready?
subpoenas. I was waiting to see if they were gonna show up or not, Your Honor, and they
Okay,
have not
sure.
shown up, so that's.
Quiet, please.
We didn't want to be doing this on Monday morning, so we
Sure.
figured we'd do it today, make sure they're here, and since they're not, we're gonna go
Okay,
that route.
so we'll just keep this pending while you all take care of that this morning. And I mean, do you want to take care of it this morning? or-
Yeah, of course, Your Honor, yes,
Okay.
because we want to make sure that we have them here one way or the other by next week, Judge.
Very good. State, how long do you think you need to try this case?
I've actually had Philip in charge of this. Unchanged, how long?
Guilt, innocence?
I'd say 3 days.
Okay, in addition to that, for guilt, innocence?
3-4, Judge. I
Okay.
think.
For judge or jury,
Jury, Your Honor.
probation eligible?
Yes, Your Honor.
Okay, very good. Well, y'all step back, take care of these things, and let's take care of it this morning, whatever you need us to do, and I'll read any motion you put before the court.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Good morning, how are you?
Michael Spear.
Mr. Spear, can you approach, please?
If we're not ready on this one, it's his first trial setting. We're still trying to work it out. We have not discussed that. We haven't set up a plan for a retained agreement for trial at this point. I understand he's set for trial, but we just haven't been able to come to an agreement at this point, but I think we're also very close.
Okay, well, I'll let you guys keep working on it during the week. State, your announcement, please.
Ready. Believe guilt, innocence would probably be about 2 days.
Very good. Is there any other motions? Have you filed any
Not
motions?
this time, no. I'll have to try to file one though. I'm covering this morning.
Right, very good. Well, we're set for trial then. It'll be set for Monday.
Yes, sir.
Make sure that you're here on time. We do have a custody case ahead of it, but I know that case is coming back today, so it could go away. So be prepared. I don't think that what you've laid out so far is going to be grounds for us not moving forward.
I understand.
Okay,
Thank you,
thank
Judge.
you very much. If anything changes this morning, y'all want to approach the court again, feel free.
And Judge, we do have a tentative plea agreement on signs, just so the court's open.
Okay.
But I have not seen Leland this morning.
He's here.
Oh, good.
He's
Who is
actually
it?
on all 3 dockets.
That makes sense. Council on signs.
Okay. Okay. Good morning, Ms. Brown.
Hi, Judge.
How are you?
I'm good.
Good to see you.
I'm here officially, but unofficially on Morgan Dickerson.
Very good.
His father
I'm very happy
retained
about
me. He retained me, but Morgan won't speak to me.
that. So did he retain you or his family?
Stanley did. So I'm
Okay.
technically standby, I guess, at this point. But I do think we need to bring him up because I have information to provide to the state that I think would warrant them perhaps filing a request for something.
That's the one.
Psych eval.
Can you get Mr. Dickerson up?
Family thinks he's schizophrenic.
Okay.
So
All right.
I'll step aside.
Yep. Very good. Thank you. Good morning. How are you?
Good. I have Frank Fernandez. This is our first pre-trial setting. He's in the courtroom. You can hear that.
Okay. Becky, have we given notice to the other attorneys on Dickerson?
Yes.
Yeah. Yeah.
They don't want to be here.
Yeah. Did I already ask that?
Kelly let them know.
Okay, great.
Once we
Thank you.
found out that they were being discussed.
Thank you. I just wanted to make sure we weren't wasting our time.
Yeah, no, they're-
Come on up, Mr. Hernandez.
I think this is your case, Allison.
It
I'm not
is.
sure, but I passed it along. It's already been discovered.
All right. Do you have discovery in this case?
Not yet, Your Honor.
Why not?
I just haven't received it yet, but I'll.
Okay. Well, the reason I'm asking, and I just, why not, is because it was indicted in November of 2023,
Oh,
and it's a
He-
2022 case.
he just hired me pretty recently, about a
Okay.
month ago, and I was on vacation in Minnesota for about 4 weeks.
Well, good for you. Was it pleasant?
It was very nice.
Good.
Yes, I wish I was still there, enjoying the nice cool weather and fishing.
Right.
So
Where, what, you catching that?
I did. Caught some pike. My dad caught a nice walleye. My boys caught lots of panfish. So it was
Wow.
very fun.
That sounds wonderful.
Yeah, but that's why, Your Honor. But I will request discovery. But yes, he just recently hired.
Okay.
And Judge, I was reviewing this case last week, and I did notice that we were missing some written witness statements. I have already requested them, but there may be some additional discovery coming as well. So just FYI.
There's another case here? And this one's from February 2023, was indicted on the access or the ag assault deadly weapon. Do you have discovery on that case?
No, Your Honor.
Have an offer?
No, Your Honor.
Have you conferred?
Yes, I spoke with Molly. She was okay with the reset, and she informed me that.
Okay.
Okay, well, I just received an offer.
Okay. Very good. Well, we'll do another pre-trial, but pretty soon we'll be moving towards a plea and trial setting, given that this case has been indicted for 18 months and that the date of the alleged incident is from 2022. So y'all just keep that in mind.
Okay.
So this is being resolved, whether by trial or whatever way y'all come up with before the end of the year.
Okay,
All right.
sounds good.
All right. Thank you very much.
May I be excused, Your Honor?
Yes, after you get your reset, you're free to go about your business.
Thank you.
sir.
Sure.
Does that one work out?
Hopefully.
Good morning, Mr. Mendoza. What do you have today?
Judge, you showed up a little late.
Mr. Ramirez.
Judge, I think this is our second. I'm gonna ask for one more for another trial, and you continue good with obtaining mitigation for the state. And Judge, I also was gonna,
You're waiting for mitigation.
or still obtaining mitigation from my
Okay.
client and other sources.
So understand, sir, that the attorney's in conferring and working hard on your behalf. But if he needs information for that mitigation packet that he wants to give, it's completely in your hands, not on his, right? And so we're going to be moving forward in this case. And keeping that in mind, you need to get that information as soon as possible, but you're the one who decides whether he gets it, okay? Does that make sense?
Yes, Your Honor.
Are you okay today?
Yeah, I'm okay. It was just kind of like hard to like get all like even down to like basic letters because I mean, I didn't really have any like family or friends that like believe, you know what I mean, like get recommended. It was just hard just even doing that. Just like
And Judge, I think what Mr. Ramirez is getting at is that he has been working, Judge. It's a little difficult for him. I've asked him also get some other records, counseling, similar items like that. It's taken him a while to get it, but I think he knows now to, not sit on it and get on it.
Yeah, understand, this needs to be at the top of your priority list. I want you to keep working. Have you been tested lately?
No.
If you were tested today, would you be clean?
Probably I'm gonna be really probably not for marijuana. Like just for like I do like the CB. I don't know if like
Pretrial services, can we get a test done? They're gonna do a test with you. You sure that's all it's gonna be? is marijuana?
Yes, Your Honor.
Okay.
Judge, before he goes down, I want to also ask if I could approach the court either later today or tomorrow for a motion to appoint an investigator.
Yeah, can you get your whatever motion you have ready? Right. So she's gonna take you for that and make sure that you come back afterwards, okay?
Thank you, Judge.
All right, look at this one, please.
And Judge, we have Mr. Dickerson up as well.
All right. We have someone in custody. Let me just take them real quick. Mr. Dickerson, can you approach, please? Morning, sir. All right, we need to communicate today, okay? So I understand that you or your family has hired you an attorney?
No,
Okay,
that's not actually the case.
okay. Ms. Brown?
Yes, Your Honor. His father's name is Reagan Dickerson, and he's actually a family friend.
Irrelevant. I'm representing myself. I don't know what you're talking about.
And it's
Irrelevant, like I said.
Okay.
No.
We're not gonna interrupt her.
Pro se, I'm representing myself. My father, I haven't communicated with him in a significant amount of time. Legal defense on my behalf, no, I'm pro se, and I'm representing myself. So that's who she is irrelevant. It's just.
Okay, well, what I want you to do is please, for a moment, allow her to talk to the court, okay?
For what purpose? This is abnormal.
It's my understanding that Mr. Morgan Dickerson is pro se. He's representing himself. Family has hired me as standby because there was a concern for potential mental illness, and we feel that that has not been properly addressed. As the case is still pending, we'd like that to get addressed. I can offer some information, which I've already offered to the state, so that they perhaps can make, or the court can make on its own motion, a request for compensating insanity at the time of the offense. It's imperative that that be done at this level. It's going to come back on appeal.
Okay, well, bring something to me. I have gone through the Faretta warnings with him. I've done the informal hearing as required in the code. He is always presented himself as knowing what is going on in his case, as knowing what is happening, and he has a right to represent himself. He's chosen that right. I've always honored that right. Is that not true, sir?
Mm-hmm.
And so if you want to submit anything, you may, but it needs to run through him as well.
I understand that.
He needs to know what's being done. If you would, I'd like you to speak to her for a moment.
No, it's not necessary. I've already declined, and I don't know why she's here.
Okay. Well, I understand someone in your family has,
No,
you've talked,
irrelevant,
okay, let
Pro
me
se.
finish. Let me finish.
we all know that, so it's who she is. Like I said, this is the conversation we don't need.
You have talked to me on multiple occasions about your father. You said. it's
Have
your-
I?
Yeah, you said a car is your father's, right? Have you told me your car is your father's?
No,
Oh, okay, you have. I didn't make that up. You don't remember that?
no. We never discussed our vehicles together, no.
Okay. Nevertheless, you have discussed your father. He has been a part of this in one way. Who paid your bond?
My fault. That's the only
Okay.
part he's played in
I
this.
thought I remembered that because your father has been involved and you told me about your father. He's paid your bond. You've told this court at one point that your vehicle was in some way related to your father. I don't know what it is. And now your father's involved again in a way. So I'm hearing that he's been involved up until now, and he's now asked this attorney to be involved. Here's what, in the end, whether you're going to take her, I'm going to ask you to be respectful to this attorney and speak to her for a minute so she can tell you the information that she has.
I apologize, but like I've stated, I have declined whatever services she's offered, and it's not under consideration.
Okay, well, I want you to just go and talk to her for a moment. You cannot.
We're not gonna speak. I don't know who this is, and we're not gonna speak. I don't need your services. So, no, thank you. How we proceed? Because some random person shows up saying that she wants to, I don't know, go through a gamut of things that I find are unnecessary, and suddenly I'm schizophrenic. That makes no sense. Like I said, does the court not see why I might decline conversation or any association with this?
Well, here's
I think it's
here's the
obvious.
thing that I know. This attorney is well respected in the courthouse.
Is she? I mean, we're all hearing this.
As she is, she's well respected. I respect her. The other judges respect her. We have heard her to cases. And she is on our list of important attorneys who will be appointed. So I respect what she has to say, okay? And I want you to speak to her, even if you only speak to her, because she's going to have to report to me what you said. Even if you say, if you sit down and respectfully tell her that you don't want to speak to her,
I just
you
do
can
that.
You're gonna do it over there.
I understand what you're saying.
Because she's going to report to me, and she needs to report to me how your conversation went. All right, now, let me ask you some questions. And this is part of the issue of whether you are going to represent yourself, is how you answer these questions. I have to do this under the code. I have to ask you, as I have, do you know who this person is?
I've seen her before.
Okay, and do you know what her role is?
At these proceedings here today, no.
Do you know what her role is generally?
Representing the state.
Okay, what is the state's role?
Why would I need to answer them? She's right here. She
Right,
can
so-
state her purpose.
So this is part of what I am required to do under the code, is to ask you your understanding of these proceedings. Okay, and this
I was
goes.
taken here in handcuffs off a cement block. So I am being informed of the proceedings and what their purpose is right here and now. So she can inform me.
So here's, let me just tell you what I'm trying to figure out. Are you not answering these questions because you don't understand them or because you are unwilling? Right, because that's a big difference of how we proceed. Are you unwilling to answer the questions because you believe that this is your right to?
I'm not answering the questions because I don't know the answer.
Okay, well
Because,
then, if
like I
you don't know
said-
the answer, then it sounds like you don't understand the proceedings that are going on. Please get me the paperwork to do a competency and insanity hearing.
Yes, Your Honor.
Okay.
Like I
step
said,
back,
I was
step
not
back. We're
informed why I was
I
brought
tried
here.
to ask you.
Okay.
Okay.
Thank you, Your Honor.
If you would, please just a brief moment.
Yes.
Because that will be part of what you tell me in your motion.
Nothing. I told you downstairs, and I told you now. Proper, and I'm not speaking to you. Under any circumstances.
Thank you. Mr. Ursha, how are you?
Good morning, Judge. May I approach?
Yes.
Joe Cappuccino, nice and easy judge. I just got hired on 7/22, waived arraignment on 7/23, got discovery about a week ago. We got it resolved potentially to wrap it up downstairs on a pre-filed case. As soon as that gets filed, we're gonna have about a 60-day reset. I don't think we'll ever be back up in your court, Judge. We've got an offer from the state to resolve it 2 different ways, but we like the offer downstairs.
Okay.
But we need to have it filed. So if we give it 60 days, Judge, I don't think we'll ever
I
be
think
back.
they're getting them done in 30 days because we have to reset for 30 days to make sure things are happening. What happens is the reason I'm going to set it for 30 days and it can be done, or maybe you come back and tell me this, but relying on what's happening there is sometimes holding up our ability to move forward because then if it falls through, now we've lost a setting. And so
It is a first pretrial setting, though, Judge. That's what I
I
would say.
agree.
So-
I'm going to reset it.
Okay.
What I'm just saying is that we're going to just do a 30-day reset. Maybe you come back and tell me the same thing, or maybe you have it taken care of by then. But we're going to stay on the pattern because sometimes it doesn't happen. And then when it falls through, we go, well, we haven't had any settings lately. So that's why I'm doing it. Sounds like you disagree with that, but.
Oh, no problem, Judge. I'm just saying it's a very new case and we.
I understand it's a new
yes,
case and I'm
we're
going to give you the reset. So that's the fun.
No problem, Judge.
Okay.
Thanks, man.
Yes, sir.
Excuse?
Yes, you may.
Thanks, Judge. Appreciate it.
Morning. How are you?
Well, I'm here, Francisco Flores.
Flores. Mr. Flores here?
Yes, Judge. You want him up?
Yes, Mr. Flores, can you approach, please? All right, last time we were here, we discussed the state needed to provide CPS records. State, have you been able to do that?
Judge, I'm sorry, I didn't hear which case this is on.
Flores, please.
Judge, I think those are still outstanding. I thought, it's Ms. Schmidt's case, but the last update we received is that we're still waiting on those.
We have subpoenaed them, Judge. I don't know that we've gotten them in yet. Let me just check real quick.
I understood on July 23rd that we expected to have them. So just give me an update.
We did issue a subpoena on that date, Judge. I'm checking the date on the subpoena. Don't see that it actually had a due date, if you will, on the subpoena, but we have served CPS with that subpoena. It does not appear that we've gotten anything back. I will ask our investigator to follow up.
Okay, last time we were here, I told you of the timeline due to the age of this case. It's already over a year old, and the allegations are from 2020. So what we're gonna do is a 2-week reset to come back and answer this question. The next setting after that will be a plea setting. That does not mean that you have to plead, but if there's not some resolution, the setting after that would be a trial setting. I only tell you that so that you understand the timeline that you're looking at. Understood? So Becky, please do a 2-week reset on that.
Okay, we already have a docket set on the 9th. Is 3 weeks okay?
Yes, thank you.
Thank you, Judge.
All right. Have you received your reset? You're free to go about your business. Anyone else ready to go? Courtney, are you ready to go?
No, Your Honor, I'm present, Ellington.
Okay.
Right.
I will take a break.
Go right ahead. All right. Samuel Ariola.
Okay, trying to issue a benchmark for him. And I don't think that it was executed.
It was not executed?
No, I issued it for Bear County, and as of August 1st, 2024, he's no longer in Bear County. So it looks like I need to find out where he is.
Okay. Josue Crispin Efehinio. Come on up, sir. Or I apologize. You have an attorney? Good morning, sir. Do you have an attorney?
Sí tengo, abogado.
¿Tienes abogado?
Sí.
Okay. Okay. Bueno, entonces pásale a la banca.
Okay, gracias.
Just wait at the bench. Cecilio Fabian. Thank you, sir. It's just the case we've been dealing with where the deduct and everything. Good. Tommy Garcia. Come on up, please, sir.
Keep your hands over your pocket.
Morning, sir. Thank you for being here on time.
Sure.
What are we here on in this case? I don't have anything in my file.
It's a show cause hearing requested by probation.
Okay. Probation.
Your Honor, we have. On 5/23 of 23, the defendant submitted a positive urinalysis for cocaine. And he was dropped for the intensive outpatient program on February the 16th of 2024.
due to excessively missing classes. After that, he failed to enroll in the intensive outpatient program. And we were requesting that he go to the Travis County SMART program, and he refused to sign them in conditions for such.
Very good. Why weren't you showing up to those meetings or to those treatment programs or to those testing times?
I was in the treatment, but they didn't have a full-time teacher, so it was every other weekend. They didn't have a teacher, and I was still paying, and the teachers wouldn't show up, so I just stopped going. And after that, I didn't have rides.
In what program was the teachers not showing up?
ADAP.
ADAP?
Yeah, ADAP, IOP.
Okay, what I'd like you both to do, if you would step back and y'all discuss the status and see what we need to do. Okay, make sure that you're cooperating with her. She's here to help you.
Yes, sir.
Okay,
Yes, sir.
so she's gonna give me a report on what's missing and what's not.
Okay.
And so cooperate and we'll figure out what's gonna be best. The thing is that we, looks like there's some issues with substances and we wanna get you help.
Yes, sir.
All right, so make sure you talk to her and don't take off before we've talked again. Hello, sir.
So I'm here for Jose Palacios Perez.
Mr. Palacios.
He's a Spanish speaking judge, but I'll translate for him.
Okay.
Okay, so we do have a new offer. So the state has generously offered if he's willing to pay the restitution amount.
You don't have to tell me the offer.
Okay.
And the only reason I say that is because I think that if the judge doesn't need to know the offer because y'all are negotiating, it may change. And I just want to always be fair to you. Okay.
So we're just pending the amount that's owed. So the prosecutor will get in touch with the victim, get us that amount, and we'll get that restitution paid. That we can get this pled out on the next, hopefully the next sitting.
Okay.
We will ask for the most you can give us, 45 days to give the state time to get that amount to us and give my client the time to accumulate those funds to make that payment.
State, how long do you need to get the restitution amount?
I would hope that we'd be able to get that within a week, Judge.
We don't already have it.
We don't have a final restitution amount, no, Judge.
Do we have an amount to the indictment?
We did have that amount, Judge, but we want to make sure that because we don't reimburse insurance companies that have paid out, so we need to make sure that what's being reimbursed to the victim is what he's actually out of pocket.
Let's get on that. So we'll do a 45-day reset, but it'll remain on the trial setting. Okay, we talked about that last time.
Yes, sir.
So make sure that if your attorney is requesting information from you, that you provide it, because he's found an agreement that is helpful to you, right? But he needs your information going forward, so it's going to rely on you. So you can tell them to step back.
Yes. And do we have the reset
And
one
so
on it?
she'll give you the reset. All right, thank you very much.
Thank you, sir.
Okay, Mr. Michaelowicz, want to come forward? Are you ready?
Sure.
How you doing, sir?
Could be better.
I know, I was hoping not to see you again,
Yeah.
but that's all right. You're here on time, and I appreciate that. Were you last here in July of 2023?
Yeah.
I believe that's.
That seems like 2 weeks ago.
Well, Judge, then you must be approaching my age, because that's the way time seems to fly.
So you're here, you're always here timely. We waited forever. Weren't we waiting on discovery for a long time in this case?
There was a re-indictment. No, not on this case, I don't believe.
I don't believe.
Very well.
But
Well, anyway, it seems like it was just yesterday. What's our status here? We're here on a motion to adjudicate.
this is our first setting. The court asked me to file notice. I have.
Okay.
It's still pending in the e-file.
Okay.
I've talked to probation, or at least in the report, I've conferred with the state. I'd like to request discovery, time to request discovery.
Okay.
Let's go where we are.
All right, we'll set it for a contested hearing in 30 days. If y'all have something worked out by then we will, we can take that at any time. If not, then we'll do whatever it is the state's, we'll take a look at what the state's evidence is.
Okay, but am I allowed to
Get discovery?
have discovery on
Of course
that
you are.
and prepare on that?
Of course you are.
Oh, okay.
That's why it's 30 days. I mean, what's the allegations?
It's a
DWI.
DWI.
Okay. Well, the state has a motion to adjudicate. If they're not able to go, then we won't go forward. If you're not able to go, then we won't go forward, but we're setting it for a contested hearing for 30 days.
Yes, sir.
And it looks like we do have the out-of-county discovery, the videos, reports and whatnot. So all you need to do is submit a request to our office and we'll email you the link.
So you can get that discovery, you can send that discovery to him today.
Yes, we just need the request.
My notice actually has a discovery request built into it. So.
Do you know that?
I don't know that we've received a notice of
It's
appearance on
sitting in
this.
e-file waiting to be.
Okay.
I literally filed it, sitting over there when the court asked me to.
Very good.
I'll go ahead and ask Jane to send it.
There we go. All right. Thank you, Beth.
Thanks, Judge.
All right, Mr. Cray, how are you? Mr. Stein's coming up. Are we here on your case?
Yes,
Okay,
we have a plea agreement.
we do. Very good. Have we done the paperwork?
Yes, sir.
We're gonna do that now.
And Judge, I am going to ask for a sentencing date. Victim's family did want to be present and give victim impact statements. So I would ask that we have a new date for that.
We're waiving PSI, so I think it would just be for allocation.
Correct.
PSI.
That's what he said, yes.
Okay.
Let's see. I'm gonna ask for evidence in this case.
Judge, I would ask that if the court is intending to review the offense report, that we do go ahead and set it for PSI, not for the full report, but I'll provide the offense report. I actually have a copy right now to probation.
I can provide it.
PSI. You can provide it.
Oh, well, then I won't waive PSI if the court wants to that sentencing, or I can provide the police reports.
I'm not going to accept a plea on a murder case if I don't have evidence. If this is the state's position that they will not give district judges evidence on a murder case so that I can see that everything is consistent with Texas law as a judge should do, then we'll just go to trial next week. Unless you want to offer it. Because the state can't, well, refuses to offer a district judge evidence in a murder case. What is being hidden from the court?
Judge, it's not a matter of hiding anything. It's just a matter of how the court accesses it. Because if we admit it, then the entire report, including everyone's confidential information, has been part of the public record. Whereas if I provide it to probation, which is an agent of the court can then review that report.
We're not. All right, if you don't want to give evidence, you can decide if you want to give
Yeah,
evidence.
I'll go print it out.
Okay.
Yeah, I'll go print it out.
I would just ask that you redact.
Not a problem. I'll redact it, the dates and like social security numbers and stuff like that. The law library printed out.
Actually, counsel, do you want to use my?
If you allow me, Judge, I just go down below my remarks and stuff.
Of course. you may. In Ellison, I've signed the waiver.
Yes, he is, Your Honor. He is wanting to plead today.
Did you never give evidence to judges in other counties?
It's just a matter of how we do it. In Comal County, we did offer the offense report, but the judges then sealed the offense reports.
So you did offer evidence to judges in other counties or in another county that you've been in?
Where we had procedures in place to ensure that the information in it was protected. Yes, sir.
I mean,
In Harris County, I never offered an offense report.
where is there some sort of information in there that is prohibited by law from showing the court?
With 3914, when we provide it to defense counsel has obligations under that code to keep certain information in that report confidential. So the identifying information for parties, names, dates of birth, home addresses, phone numbers, and all of that, they're responsible for keeping confidential. So we can provide it to them without any redactions because it's required in the code. But that obviously doesn't apply to the court.
So you can provide it, means you provide it to the defense attorney.
Unredacted.
But not the court. You can
Because
provide it to me redacted, right?
potentially, yes, but that puts the burden on us to redact every potential report.
Well, I don't ask you in every potential case. I've asked you in a murder case, which I think rises to the level of pretty important. And you have time and the defense can go do it.
And just, it's just a matter of,
So if I give you time to go and redact from those reports, would you provide the state? I mean, would the state provide the court with evidence?
I would have to double check what the policies of the office would be, Judge. But
Because what I'm hearing is the policy of the office is that you won't do it because of information.
correct,
We've just discussed a way to get that information out of the public's review, right?
yes, sir.
That seems to cover for what the policy is intended to cover, unless there's some other reason that you want to keep evidence from the district court judge.
No, Judge, I think the only other issue with providing the court with the offense report is it gives a basis to argue that the court has had access to information that would bias the court. And so there would be a basis for a request to recuse from the defense. That's the only other concern that I
So
can think
it's,
of.
the policy is to save the court.
That would be my only other concern regarding it. Yes, sir.
Okay, so identifying information, or the court would be unable to hear cases.
Correct.
So, for instance, in the other county where you provided it, but it was sealed, was there that concern that judges were regularly recused because they had seen information in a plea agreement, police report?
No, Judge, in my experience in those counties, the judges didn't often review the offense reports. They were attached as part of the plea agreement, but they were not typically reviewed by the court. It wasn't something that came up.
So the concern is, I might read the report. I mean,
I think from the defense's perspective, obviously, if there's a plea bargain agreement, the state reviews the offense report and rejects the plea bargain agreement because the court does not feel that it's appropriate, they then have a basis to ask the court to recuse because the court has reviewed that information.
Here's what would happen. You would offer it with the information taken out. So the issue that you've raised has been curtailed. Then you offer it and they can either object or say no objection. If they say no objection, then I can read it, right?
Correct.
Okay, so we have a policy there to cover for your second concern.
I don't think that that fully addresses the secondary concern. I think just because they don't have an objection to reviewing it as part of the plea, I think once the plea, if it is rejected and we go back to square one, I think at that point, they would have a basis to ask the court to recuse.
Have you ever seen that scenario play out?
Here, yes, sir.
Where?
I saw it with Bo Dresner and Judge Tibby.
And what happened?
She recused. And we had to get a visiting judge to cover it.
So we come in and hear a motion to suppress and the information. The court finds out information at that time. Don't I find out what's going on in a case and then I'm not recused?
I agree with the court that it's kind of a catch-22 because the court does have an obligation to make inquiries to ensure that the plea bargain that it is essentially signing off on is in the interest of justice and compliance of the law. But I think anytime you are exposing yourself to factual information about a case, it gives the defense an argument or the state an argument to say, Judge, you have been exposed to information about this case that would prohibit you from potentially being a fair jurist in this matter. And especially
So
when
anywhere in the state, for instance, state fair, they provide it in every case, they provide evidence. Every single one of those judges, every time they take a plea agreement, thousands of plea agreements are all subject to recusal.
upon request of the party, potentially, yes, Judge. Nothing is an
Okay.
automatic thing. I just think
Well,
it's a concern.
I mean, I guess that's fine if those are the two reasons. I don't see that they're a concern here. And, you know, if I don't have evidence in a case like this, then we'll have to go to trial and the jury will get the evidence.
I understand.
Okay.
And I believe defense counsel is redacting that offense report because the redactions are on him and his liability. I'm not going to ask to review it. So it's my copy. It should all be there. It should have all the supplements.
So I guess they'll offer it. And if it's the policy that I not receive reports, then you can object.
I don't intend to object, Judge. When it's the defense offering it and they've taken the responsibility to redact, the liability for any failure to do so would be on them.
So where is the liability? You say 3914?
3914 requires the defense attorney to, before providing any of the protected information.
Okay,
from
but where does
parties-
it limit you from giving the court information?
No,
You
that's
said
not what
there's
I'm saying.
liability.
Anytime we are releasing information, there's a potential liability there.
And so you can go through, you told me, and redact.
I can, but for example, if I miss something, then I still retain that liability for that.
Okay, so where is that? I just want to read it and see where you're telling me that there would be liability.
I don't know that it's necessarily in the code, Judge. It's just a general
Well, that's what
disclosure.
I mean, if we're not being driven by the code, what are we driven by?
Becky, did you want those motions to transfer?
Christopher Williams, and Elisa Borman and Michael Egan. Yes, say that 10 times fast. So I have them for
And I tried to put in there specifically, like, not only does she have a lower cost number, but she's also in supervision in the 22nd.
Yes.
Because I know Judy usually likes to send stuff here, and I'm usually fine with that, but I can't because she's in supervision before.
And Judge, when you have a moment, that's the agreed protective order for those CPS records.
Morning.
Morning, Your Honor. May I first?
Yes, here you on.
I'm here on Mr. Paul Tompkins on behalf of Jeremy Silverstein.
Okay, great. Thank you.
Of
Nice to meet
course.
you.
Mr. Tompkins?
Yes.
No, to my understanding, he's not appeared. Mr. Silverstein has asked me to present to the court this motion to withdraw for consideration.
Okay.
Based off of the fact that we've not had contact with him. He's not fulfilling his obligations with us in terms of our legal services agreement. We filed this last night. The state doesn't have a position on it. My understanding is the court intended to revoke his bond this morning if he did not appear.
Well, he was supposed to be here yesterday, and so the court gave him 24 hours to appear. So I understand he's not communicating with. Was he in for Is he on probation now?
So he was pending a PSI, and the officer also told me this morning she attempted to contact him yesterday to advise him to be here as well. No luck, Your Honor.
This is bond. payment?
I believe it was increased to 25,000. He was arrested and bonded out again.
Deputy, can you call his name for 3 times in the hall?
Yes, sir.
15,000? Someone else? Anyone else? See anything different? You see 15 also? What made you think it was 25?
I could just be mistaken, Judge. I'm just going off of memory.
Okay, no problem. State, do you have to see?
It looks like it was originally 10, it was increased to 15.
And at this point, I don't have his stance on the motion because we've not been able to talk with him about it, despite our attempts. So that's the status of this motion.
Issued a warrant for $25,000 for a bond violation and probation.
Is that active?
Yeah, and on August 13th.
Is this not the one that we withdrew? Because he did appear again?
Show that it was withdrew, show that it was executed. You withdrew, this is the one you withdrew. Reinstate original bond at $15,000 surety with all previous bond conditions and the additional condition of the defendant appear in court on Monday, August 19th, 24 at 9 a.m. Please release from custody today. And that was done on Friday.
Has probation had any contact with him?
No, sir.
Have you completed the PSI?
No, sir.
Have y'all had
There
the?
there was positive UAs, but there was a partial meeting. It appears.
Have you had the? PSI interview yet?
So she did finish the interview with them.
She did
I
finish.
just asked, yes.
Okay. And what's the status of the report?
I can check.
Okay, thank you.
Judge, she said she's gonna staff a recommendation possibly tomorrow.
Okay,
That she
great.
just finished the interview last week.
So when we get him back in, we'll have one more setting to do his sentencing. Can you appear for that?
How should I phrase this? I have been instructed to present this motion to the courts by my supervisor.
Okay.
I
so,
leave it to the
I
court's
mean,
discretion.
Understand that what I'm asking you and see if we can have you come back. It's gonna be a one setting. We'll know when that next time is. Now it's gonna be because he's gonna be held in custody. So he'll come back and we'll do the PSI because he's not appearing. So it'll be a warrant issue. So if you, can you check on that for me?
Yes, absolutely.
All right, thank you. Augustine Schulke. Let's call that name 3 times.
Yes, Judge. The last one, Thompson, so we're gonna, what's the bottom up?
Yeah, yes. It's 25.
Okay.
We heard from Ms. Collins on Crespin.
Asked the office to call her twice and probably 9:54, she said she was 15 minutes away.
Okay.
I did review that case and I do have a motion to dismiss on that case. I don't know.
Which case?
The Josue Antonio Crespin, that last name. Josue Crespin is the, then it's a hyphenated.
One of them.
It should be under the C's.
Dismissing.
Yes. Cannot prove.
Assault, family violence repeater, have you given notice to the victim that you would be?
We have, Judge, we've had extensive conversations with her.
She knows that you were going to dismiss?
She is aware
Okay.
that that is a possibility, and we will confirm with her today that it has actually been done. Thank you.
CR 24-1341F. Does anyone know that case number? The case on which Ms. Collins is the attorney. Can you see if you can find that person? Can you see if you can find that person?
Crespin Efehenio.
Gentleman back there in the khaki color shirt that spoke Spanish.
Okay.
That's what my notes were.
Had the opportunity to review the PSI. He denies guilt for the charge. So
I can try to rehabilitate him if the court would be interested in hearing.
okay. Yep, we can do it. I just want to give you a heads up, and you need to talk to him about it in advance so that you know.
Thank you.
Sorry, the case has been dismissed. You're free to go about your business.
No, but he understood.
Está libre. Se vaya. Con Dios.
And we did get those Wells Fargo records in from yesterday on
great.
Kim Blunt. I have already emailed them to defense counsel.
Who's the attorney on that one?
Aaron Seymour.
Very good. Thank you very much.
Yeah, it's on my list. Right after figuring out how to make the feds listen to me and CPS give me records.
No.
Yes, ma'am.
We're ready for citizens, the court's pleasure.
Been married into it for 35 years.
Do you have Cecilia Fabian?
Me too.
You ready on that one?
Yeah.
Okay. Cecilio Fabian, Ruby, are you ready?
Yes, sir.
Seconds.
Do you understand?
You
can.
No,
if you-
no. If you,
I mean, I just.
yeah. Court calls CR 240921F, the state of Texas versus Cecilio Fabian Jr. Can council please make their announcements for the record?
Allison Boost for the state.
Cliff McCormick, attorney for Mr. Fabian.
And are you the same Cecilio Fabian Jr. who in CR 240921F pleaded guilty to possession of a controlled substance with intent to deliver methamphetamine 4 grams or more, but less than 200 grams?
Yes.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
We're here today for your sentencing. You previously pleaded open to the court with a cap of 20 years in the Texas Department of Criminal Justice. Was that your understanding of the
Yes.
agreement? That means the court has the full range of punishment. Can sentence you between 5 years and 20 years. That's not the full range. The first degree is 5 to 99, but you here are 20 years. Also, the state waived the enhancement paragraph, which would have made it a minimum of 15.
Yes.
Now it could be as low as 5.
Yes.
Is that your understanding? I also understand, have you put in an application for deferred adjudication?
Correct. Probation, correct.
Okay. All right. I've gone through the pre-sentence investigation report prepared by probation for the court. Counsel, have you had the opportunity to review that report and discuss it with your client?
I have, Judge.
And are there any modifications or corrections?
There is, Judge, and I can call my client to testify to the issue at hand.
Okay. Sir, I've put you under oath. You remain under oath for these questions.
Mr. Fabian, we've had a chance to talk about the pre-sentence investigation report, is that right?
Yes.
Okay. There is a statement where you are saying that you are not guilty of this offense. Is that what you told probation or not?
No.
You told them that you are guilty of this
Yes.
offense. And would you agree that all conversations, without revealing what those conversations are specifically with me, that that's never been an issue? Guilt was not ever an issue, correct?
No.
Okay. And you're still today, as we sit here today, saying you are guilty of this offense and for
Yes.
no other reason, correct?
Yes.
And you understand that you didn't plead guilty for some sort of leniency or some sort of plea bargain, correct?
Correct.
Okay. That's it.
No
Okay.
questions.
Okay, so my question here is that in the, your version of the events that you told to the probation, I understand what you're saying here is they may have missed what they put down, is that right?
Yeah. Yes, I told them I was guilty.
Okay, so, but here's the question of what you're guilty of, and we need to make sure that the charge lines up with your understanding of what you were pleading guilty to.
Okay.
Okay, and so the question is, did you knowingly possess methamphetamines in the amount of 4 grams or more, but less than 200 grams?
Yes.
And did you possess that because you had the intent to deliver those drugs?
Yes.
Okay. So the statement, he maintained he was not selling drugs at the time of the offense, is incorrect.
Yes, it's incorrect.
Very good. All right, is there anything else that you need to correct or modify?
Not on the PSI. I do still have some evidence to present at the appropriate time.
Okay, is there any legal reason we can't proceed to sentencing?
No.
Okay, argument from the state?
I'm good with the PSI, no corrections or amendments, Judge.
Okay, argument?
Judge, I'd like to call my client to testify to some of the things that the court would consider if the court were to probate his sentence.
Okay, go right ahead.
Mr. Fabian, you would acknowledge and admit that you have an addiction to
Yes,
cocaine. Wait, you have to
Hold on
finish.
one second. Let me just tell you, sir, she's taking down everything that we say today. So what we need you to do is wait until the attorney has finished the question, and then you begin your answer. And he won't ask another question until you've finished answering. Is that a deal?
Okay.
All right, thank you.
I'll repeat the question. Would you acknowledge and agree that you have an addiction to cocaine as well as methamphetamines?
Yes.
How often do you use?
Every day, every other day, something like that.
Okay. And would you agree that if the court were to grant you probation, that you would like to get help for this addiction?
Definitely, yes.
Okay. Now, you previously had treatment approximately 14 years ago, is that right?
Yes.
Okay. But you haven't had any treatment since then?
No.
Okay. So why do you think that getting the treatment now would help you with that addiction?
I'm getting to where I can't hardly move anymore on my own. I've got a place I bought in Northern Alaska, sit down and fish, and I'm done. I'm just trying to get over this, get away from everything.
All right. Well, you understand you may have to, if your sentence is probate, you may have to stay in the state of Texas until your probation is complete.
Yes.
Okay. And are you asking the court to consider giving you probation with the understanding that you would go to jail waiting for a bed to go to safety?
Yes.
Okay. And do you think that you can complete this probation successfully once you've had that treatment?
Yes, I do.
Okay. What are your physical limitations?
I got a bad hip, a toe off each foot, can't hear with this here, can't see with this eye. Just a whole bunch of.
Would you have someone to assist you to make sure you go to your probation meetings and
Yes.
comply with the conditions of probation?
Yes.
Okay. Pass it.
No questions.
Okay, argument?
One other witness, Joey Williamson.
May I approach, sir? I want to ask you to just stand right here, right, just right here. Just that right there is good. If you'd raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay.
Now, Mr. Williamson, state your name for the record.
Joseph Williamson.
And Mr. Williamson, do you know Mr. Fabian?
Yes, sir.
How do you know him?
He's my neighbor.
Okay.
Just a second. Sir, when was the last time you used drugs?
It's about a week.
I mean, you're scratching right now. You can't look. Your eyes are darting.
No,
Are you on a substance right now?
No, no, sir.
Okay. I'm going to take into consideration the way you're acting and what you say. You can continue.
I'll pass the witness.
Okay. You can step. Do you have any questions?
I don't.
You can step back.
That's all I have, Judge, just argument.
Your argument, sir.
Okay. So, Judge, we asked for you to take judicial notice of the PSI, the probation's recommendations, and consider to giving Mr. Fabian the opportunity to complete the probation successfully. He has some physical limitations, obviously. It's my understanding that he would be eligible for special needs safety. He would like to have that opportunity to complete that probation. He wants to get off these drugs. He does not want to have to use these drugs. I think that that's really the only alternative from a treatment standpoint that Mr. Fabian can do. Alternatively, the court can consider sending him to prison, but that will not address the issue because eventually he will get out. And they will not have addressed his issues with drugs, methamphetamines and cocaine, two very hard drugs that safety could address if he's given that opportunity. He's asking for that opportunity.
So I understand, do you think that you said you're done, you have property. Do you think you've already kicked the habit? What do you mean when you say I'm done?
I'm done as far as, 'cause I just had a birthday party for my middle daughter. And I just gotta get with the family, the grandkids, all that. And on Alaska, that's here in Texas, it's Lake Livingston.
Okay.
Everybody thinks I'm moving to Alaska.
Okay. You also tested positive very recently.
Yes.
When were the last times that you tested positive?
The 12th, Your Honor.
August 12th?
Yes.
So 8 days ago, a week ago?
Yes.
Have you used since then?
Yes, I have, and I'm trying not to, and just my pain, I need to go to the doctor and get pain pills.
Okay. Any legal reason we can't sentence at this time? State?
No, Your Honor.
Defense?
No.
Court sentences you to 10 years in the Texas Department of Criminal Justice. That will be suspended for 10 years. You will do the substance abuse felony punishment facility special needs. You will be taken into custody today. You will be on the specialized caseload with probation when you exit that facility. It will be the caseload for substance abuse. You will have supportive aftercare after you get out. You will do AA and NA at least 3 times per week. Have you ever done those programs?
Yes, I have.
Okay. Were they helpful?
Yes, they did.
Okay.
I quit drinking, I didn't do drugs, anything for years. And it just, a Super Bowl party got me going on it again.
Okay. Well, we know that that is one of the most successful ways to you to kick this habit. And if you really want to, you'll be going at least 3 times per week, and you will provide proof of that to probation. All right.
Yes.
Get your sponsor and get involved in that program. It can be very successful, and you can get out and be, sounds like what your priority now is to be with those grandchildren.
Yeah.
That middle daughter, right?
Yes.
Is that true, or am I?
No, it's true. My daughter's in the hospital right now. She was gonna be here to be with me.
Okay.
She's been with me how long?
All right, well, take advantage of this. Probation is here to help you. I am giving you a sentence that I hope helps you to overcome this addiction. You will do the drug offender education program, pay restitution, take regular UAs, and you will find some way over those 10 years to do 250 hours of community service.
All right.
Judge, we would request that the court maybe waive the fine in court costs and attorney's fees considering this indigency.
No fine, court costs or attorney's fees. But you will pay the restitution and the supervision fee. Understood?
Okay.
That pad's right there.
Anything else we need to take up?
I think there would be a dismissal on the other case. With state.
Mr. Fabian,
I have followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. Good luck to you, sir. I hope you're
All right.
successful.
Thank you.
That was on 092.
Yes.
All right. Good morning. How are you?
I'm doing well, thank you. How are you?
Nice to see you.
Nice to see you too. I've been running back and forth the whole length of the floor, so had a minute to stop huffing.
At least you didn't have to go to the outside.
Okay. State, it's your intention to dismiss failure to register as a sex offender?
Correct, Judge.
The evidence is insufficient.
After reviewing the sheriff's records of his compliance with the registration rules, which I was shown today, as well as new testimony from the, I guess, main witness in this case, we don't believe that we would be able to prove the case.
Okay. I've signed the dismissal. Your
Good.
client's free to go about his business.
Appreciate it.
Yes.
name? April, E-N-G-E-L.
And Judge, state has a second dismissal. This is on, we had you sign this one yesterday, but there was a pre-file cause number on the top, and the court's clerk's office asked us to provide another one with the correct cause number, and so that is what this is.
Very good. Thank you for the correction.
Thank you, Judge.
And that's the dismissal on Mr. Fabian's other case. Ms. Brown had provided me with those on Mr. Dickerson's case.
You agree?
I do, Your Honor.
You agree to the, only to the
Evaluation.
evaluation.
Correct.
I'm signing these not because I believe that he is, but rather I can't discern from due to his unwillingness to answer the questions.
I believe it's in the interest of justice for a professional to take a look at him.
Can we pass those to the coordinator, please?
Quick question.
Yes, ma'am.
On the PSI, is this going to the evaluation? We can still proceed.
Do you want to do that?
Yes.
You're just double check.
Yeah, yeah. No, that's a good question. Okay.
Hi, Judge.
Hello.
May I approach?
Yes.
On Mr. Tompkins, I'm fine with withdrawing my motion.
Okay.
I'm happy to, if it's just for a sentencing hearing, I'm happy.
That's what we're going to come back and do. Whenever we get him, we're going to increase the bond. The warrant will be issued when we come back. When he's found, we'll let you know. We'll come back and do a sentencing. Appreciate you all being here, your firm's willingness to do that. for the court.
Absolutely, no problem.
Thank you. Nice to
Appreciate
meet
it.
you.
May I approach?
Yes.
Good morning. I think it's still morning. I'm way off today.
You're fine.
This is Ms. Cordova. She is here for a plea and sentence today.
Very good. Can I get you two to switch?
Yes, sir.
Better up. So I have a possession of controlled substance methamphetamine less than 1 gram. State, it's your intention that she
get no treatment and just be released?
Judge, based on conversations between the state and defense, there is a belief that we would be setting up for failure, putting her on probation. We offered this.
Well, I mean, she's not necessarily going to be going on. I mean, there would be a longer probation, but there is the ability to give her treatment if she is a methamphetamine user. If all we do is let her out. By the way, you know, the most dangerous time for a methamphetamine user is when what happens right here. Actually, I'm not going to accept this plea. Here's why. The most dangerous time for a methamphetamine user is when they get out of jail. You've been out of jail for 177. No, you've been in jail for 240 days and you get out tomorrow and you go back to methamphetamine because you've had no treatment and you try to take the old dose. That is when people are most likely to overdose and die. Okay. I think that given the situation that you're in, I mean, I can take the plea and I'm going to send her to treatment. But that would be inconsistent with your plea, and so you could withdraw it. What would you prefer to do?
The other issue, Your Honor, is that she has a pending case in New Braunfels. And so when she finishes this, you'll have to go resolve that as well. And so I don't know how that would impact probation, as I expect she'll go back into custody, individual custody.
Okay. Well, that may be, but still on us, just given, I just heard this, that is the most likely time that someone would overdose and you get out and you try to do the old dose and you have no tolerance. And I just think that's something that I don't want to set you up for. So, I mean, I can take it and do sentencing on different terms. And then you would withdraw if you didn't like those terms, or y'all can agree to something that you think would work. But if y'all don't think that it's an agreement, then that's fine.
If it's okay with the court, can I have 5 minutes to
Of course
confer
you
with my
may.
client to let her know kind of what's going on and let her make a decision, and then we'll reapproach?
Sure.
All right, thank you, Judge.
Thank you. Thank you. How are you? Good. We ready to proceed?
I'm gonna bring Mr. Science back up.
Did you ask them to?
Yes, I did. So what I have done is redact all names of juveniles, but leaving their birthday, so you know that's why it's redacted in terms of the name. I have redacted all phone numbers. The only social security number or driver's license number I found was that of my client, which I also redacted, just to be consistent, trying to do that for everyone. And so the only thing the court would see are names and dates of birth for adults, in terms of any personal identifier.
Okay.
Judge, he should be walking in here in a second. I think I heard him in the elevator with Mr. Simon.
I'm not going to object, but I would still ask the court to seal it, just because it does contain names and dates of birth for adults.
And we don't object to that.
But do you think that there's a problem here, that he would face the same liability that you would face if those names are still in there?
I do, Judge, but
Okay, well, you'll step back and.
Well, I will say this. I don't want to delve too much into legal theory, but I know in Comal County, they attach all the police reports. In Bexar County, they attach all the police reports. And I've never heard of anyone being liable for that. It's for purposes of a plea. Again, it just has names and dates of birth of witnesses. If the dates of birth are a problem, I'll redact that. I'm not trying to compare and contrast. I'm not concerned about liability for purpose of a plea, but because once the plea is done, these records become public information under FOIA. I don't know if they're redacted by the police or to what extent they are. But again, it's just names and dates of birth.
I can't speak for Bexar County, but I do know in Comal County, those offense reports are sealed by the court.
Right, and I don't object to them being sealed by the court. They admitted as a piece of evidence and seal it. That's fine with me.
All motion.
Can we do an oral motion to seal it, or?
Or it won't be filed. It won't be, I mean, I'm still gonna review and the plea will go through if you're not concerned.
Oh, you're saying a subsequent motion to seal?
Sure.
Okay, and the state doesn't object to that?
No, in fact, I'm happy to file it on,
That'll work. That'll work. So with that, the defense is either one.
no objection.
Well, we gotta
Okay.
get into the hearing. Come on up, Mr. Science. Ruby?
You want me to mark that down
Uh,
before we start? Or is it marked?
It's not marked. He's got the sticker.
Okay.
Looks cool.
How you doing, Mason?
Good, so how about you?
Okay. Call CR 23-4616F, the state of Texas versus Ray Robert Sines Jr. Can council please make their announcements for the record?
Allison Boost for the state.
Leland McCray on behalf of Mr. Sines, Your Honor, left off on the record for support.
Hold on, I'm gonna run through things.
Oh,
and then
sorry.
We'll get to that. Are you the same Ray Robert Sines Jr., who in CR 23-4616F is charged with, in count 1, murder, and in count 2, deadly conduct, discharge of firearm?
Yes, sir.
The murder charge is a first-degree felony. State, what is the range of punishment for that charge?
Not less than 5 years, no more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that's the range of punishment that you face for the murder charge?
Yes, sir.
There's also a third-degree charge of deadly conduct. State the range of punishment, please.
Not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that's the range of punishment you face for that charge?
Yes, sir.
I have paperwork in front of me that indicates you would like to enter into a plea bargain agreement. I'm showing you the written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
If you would, if you just speak up a little bit
Yes,
so
sir.
so she can hear everything, okay? On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that as part of the evidence to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
Mr. Sines, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood? You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent in that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied the state fulfilled that obligation?
To the best of my knowledge, yes.
And do you believe that Mr. Sines is competent to enter into this plea today?
Yes.
The reason we talk about the evidence, because you have the right to know what the evidence is against you. Did you discuss that evidence with your attorney?
No.
You didn't. Step back and you two can talk about that. Yes, sir.
Mr. McKinley, before we get out of here, many times you order a drug test downstairs and you didn't, and before we leave, I just want to make.
Oh, for him?
Yeah.
No, I don't think I need to, do I?
Well, we're willing to.
Oh, okay.
I'm just.
No, I
Before we left, I just
Oh,
want
yeah,
to
yeah.
make sure.
No,
'cause
fair enough.
We didn't.
I appreciate it.
Thanks.
Thank you. Back on the record. We just took a moment for you to talk to your attorney, and I ask a bunch of questions, I understand, and maybe do them too quickly, so I apologize for that. But the question is whether you have had the opportunity to review the evidence that is against you in this case.
Yes, sir.
You had that opportunity? Okay. And do you believe that your attorney has provided you with effective assistance of counsel during this case?
Yes, sir.
All right. According to your plea bargain agreement, in exchange for your plea of guilty in the count 1 murder and count 2 deadly conduct, the state will recommend 28 years in the Texas Department of Criminal Justice on the murder charge and 10 years in the Department of Criminal Justice for the deadly conduct charge. You will get credit for the time that you have served. There will be an affirmative finding of a deadly weapon. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of murder, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
To the charge of deadly conduct, discharge firearm, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
State, have you given notice to the family of the deceased about the resolution today?
I have, Judge, and they have requested an opportunity to allocute or subsequent to sentencing.
Very good. State, do you have any evidence to offer?
No, Your Honor.
Defense, any evidence?
We have a defense exhibit 1, which is a very detailed police report from this matter to substantiate the plea. It indicates it's 1 through 52 pages, but just for the court's edification, it's actually front and back, so it's 104 pages. Defense exhibit 1.
Any objections to the admission of the defense exhibit 1, the case report in this case?
No, Your Honor.
And for the record, it has been redacted as the juvenile names, but not their birth dates. And for adults, their names and birth dates are indicated so the court knows that they're adults and able to give statements to the police. And then also we've redacted all social security numbers, driver's license, and any phone numbers listed within the document.
Thank you, sir. Do you want to direct me to where the defendant is tied to this case?
Yes. There are 2 witness statements where my client allegedly confesses to this offense.
Okay.
The evidence, no, there isn't much, which is part of the strengths and weaknesses of each case.
State, can family make their statement on 8:30 on Thursday?
I've discussed with them. I don't think they'd be ready by Thursday, Judge. We had discussed Friday or perhaps Monday at noon when we take a break, when the jury goes to lunch.
Judge, I will not be here on Friday. We don't have a visiting reporter.
We don't have
Okay,
the.
no record.
Yeah, there's no record for it.
Here we go. I'll probably start here and read through the interview with John Saldana. Okay. Here through John Saldana, who's on the maybe 2 or 3 pages later.
Let's go back on it. I had said, yeah, defense exhibit 1 is admitted. Based on your plea, based on stipulation of evidence and the evidence that I've reviewed, I find that there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Is there any legal reason you can't proceed to sentencing?
None, but again, I think the complaint is just, I mean, the victim's family wanted to do victim impact.
Correct.
So
we can do that, but the question is, can we?
Yes,
go ahead and do
please.
sentencing?
Yes, please.
All right, sir, having found you guilty in the murder charge, the court now sentences you to 28 years in the Texas Department of Criminal Justice. There is no fine, there are no fees, attorneys, court costs will be waived. In the count 2 deadly conduct, discharge of firearm, the court sentences you to 10 years in the Texas Department of Criminal Justice. There is no fine, there are no fees. You will get credit for the time that you've served. In both cases, there will be a finding that a deadly weapon was used. Yes, sir.
And then also, for the record, the state was going to run his MTR concurrent with these, with this case as well.
Correct. The state had withdrawn its motion to adjudicate on his aggravated assault case. The state intends to refile that. We have an agreement that he will plead true on that, will receive 20 years Texas Department of Criminal Justice, and that will run concurrent, and he will receive the same credit for time that he has served.
Okay, we'll do that today as well. We'll do that, we need to do that plea today. So you can run them together. Can you get that together, Steve?
I can definitely try.
Okay. All right, I've gone over with you what the charges are and what your sentence is. Is there anything else we need to take up?
Not this time, Mayor.
All right, Mr. Sines, I have followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be made a part of your file. Go ahead, you, sir. All right, we're on the record on that one. Let's get that one taken care of.
Working on it right now. Did you want to review my motion still?
Can we do something for you?
It's gonna take a minute.
That's fine. No problem. I didn't know if that's what she handed you.
The state has handed the motion to seal defense exhibit number 1 from public review. We do not object.
Okay, I'll take a look at it. You all can step back.
Judge, you want me to hang over that exhibit in that motion for you?
We'll talk. All right. Yes, sir. What do we have with you today?
I have Daryl Ellison, that's ready for a plea.
Very good.
I don't know, there might be somebody that needs
Is he in custody?
Yes,
Okay.
and, he's not up here yet.
And who is this?
We have Oscar Pastrana, one more.
Okay. Are we ready on him?
We are here.
Yes, sir.
I just have an announcement if I can do it.
Okay. What's that?
On Casey Blakely. Pretrial services is here. She's in treatment. That's why she's not here. She can tell you.
Good morning, Judge. How are you?
Good. Thank you for being here.
Of course, I just want to let the courts know that Cassie's doing well in treatment, really working on herself. She's obtaining a sponsor and she discharges on September 23rd. So she can't be here. We want her focusing on her treatment.
Okay. Very good. Do we know when she could get out?
23rd is of September is her discharge date.
Okay. So let's get a date after that.
Thank
very
you.
much.
That's all I
Thank you,
have.
All right,
Judge.
thank you.
And Judge, just so the court's aware, the state has filed a motion to transfer on that case that you were just discussing. She has a co-defendant that's in another court that's on supervision already in that court and has a lower cause number.
Okay.
And it's usually I wouldn't care about it because it's drugs, but it is fairly involved. And so just for efficiency, that's happening.
Do you have that notice? Becky?
I do, I have to give you this to be first for her, review and possible approval. Now, I wish to have it.
All right. Well, if it's approved, that's fine. I
Just
don't
didn't want to
approve.
surprise you.
No problem. Ruby?
I'm ready to.
Court calls CR 240807F, the state of Texas versus Oscar Guillermo Pastrana Jr. Can council please make their announcements for the record?
Philip Gibbert for the state.
John Hendera for Mr. Pastrana, Your Honor.
And are you the same Oscar Pastrana who in CR 240807F is charged with theft, 2 prior theft convictions?
I am, Your Honor.
You raise your right hand?
Yes,
You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
We're here because I have paperwork that indicates you would like to enter into a plea bargain agreement on this charge. It is a state jail felony. State, what is the range of punishment for this charge?
Not less than 180 days, not more than 2 years in a state jail facility.
Do you understand that that is the range of punishment that you face for this charge?
I do, Your Honor.
I'm showing you what is marked as the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
I have, Your Honor.
Did I swear you in?
Yes, sir, you just did.
Very good. On page 4, there's a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
I did, sir.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
I did, sir.
And is this your signature on the final page?
It is, Your Honor.
Sir, this is agreement between you and the state. I don't have to follow this agreement. But if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during the trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
I do, Your Honor.
Understanding those rights, do you still wish to proceed with this plea
I
agreement?
do, Your Honor.
Are you a citizen of the United States?
I'm a veteran, yes, sir.
All right. If you're not a citizen, the reason I ask is because this case can have serious consequences for you.
Yes.
Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied the state fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Pastrana is competent to enter into this plea?
I believe he is, Your Honor.
The reason we talk about the evidence is because you have the right to know the evidence against you in a case. Did you discuss that evidence with your attorney?
Yes, sir.
Okay. And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Outstanding.
Okay. According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend 16 months in the state jail. There's not a check here for credit for time served, but I'm assuming he would get credit for time served?
Yes, Your Honor, that's correct. About the,
You would get credit for time served? Is there? There does not seem to be anything else to that agreement. Is that right?
correct, Your Honor.
Well, he wants to make sure it runs concurrent, and I've assured him it does.
What is it running concurrent with?
He's got another.
I'm currently in state jail right now, and for the same amount of time, and I was just hoping to do run concurrent with the time that I'm doing right now. Sir.
Okay, what's that charge?
It's for another theft, sir, but prior to this one.
Okay, yes.
Excuse me, after this one.
So that is, these will run concurrent.
Yes, sir. And another thing, Your Honor, if I may, I'm sorry if I'm being inappropriate, but I was also granted presumptive diligent participation from the judge. And I was wondering if you could please grant that to me as well.
I get a report when it is requested. I get a report and it shows if you have that information. If you've received that time, I don't do it just based on what is said here in court, but we can request that report. If I get it and I see it, then you would get that time.
Thank you, Your Honor.
Okay. All right, we're back to the plea bargain agreement. Was it your understanding that the agreement was for 16 months in the state jail facility and for the credit that for the time you served?
Yes, sir.
To that charge of theft, 2 prior theft convictions, how do you plead?
Guilty, Your Honor.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
No,
Any
Your Honor.
argument from the state?
Judge, just that you follow the plea agreement.
Defense?
Just that you follow the plea agreement.
Having found you guilty of theft, 2 prior theft convictions, the court now sentences you to 16 months in the state jail facility. There will be no fine, there are no court costs, and there are no attorney's fees. You will get credit for the time you served, and that will run concurrent with your other state jail felony case for theft. Anything else we need to take up?
No, Your Honor.
No, Your Honor.
Sir, I've followed your plea bargain agreement. Because I've followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will become part of the file as well. Good luck to you, sir.
Thank you, Your Honor.
All right.
Thank you, sir. Appreciate it.
Mr. Kimball, Don, he's next in line. His client's on the way up right now.
Okay.
Pepper?
Yes.
Um,
One moment, let me write down these things. sir.
Yes, Judge, you had requested Nathaniel Ramirez to go downstairs to pretrial to do a drug test.
Okay.
We couldn't locate him at first, and I found him at the probation office. Walked him over to the pretrial office, went to the urinal to pee in the cup, and I caught him with this. He tested positive, or he admitted to using marijuana. Just the admission form.
What is that you're showing me?
This is a it's how you hold fake urine, and you have a little pouch that keeps it warm, so it's body temperature, and then that little tube is what you pees into the cup.
Okay. Thank you for notice. Let's approach on that case. All right, sir. Is there anything you want to say?
Judge, I spoke with Mr. Ramirez, and I've seen the device that Mr. Rosales has presented. Because he may be facing additional charges, I've instructed him to not speak upon this matter. The court has sent him down for a drug test, and if the court were to raise a bond on that, I understand. At this time, I'd ask that certificate in right for this false drug test, judge, and that he not be questioned about this device.
Someone tell me what his bond is now?
It is 10,000 cash rate.
Okay. Do you want to say anything as to the bond state?
Your Honor, I would ask the court to increase it to ensure the safety of the community as well as the defendant's compliance with the laws of this state and the standards of this court.
Spence?
Judge, before he went down, Mr. Ramirez and I are working towards mitigation packet. I would still like to work towards that packet to provide the state. Of course, I understand that the judge, there is some decorum in this court, especially not testing dirty for drugs. I'd ask that his bond not be raised, he still be allowed to be out on bond. So him and I can keep working towards resolution on this current case, Judge.
Okay. Part of the
judge talk.
If your attorney wants, you can speak. If you want to say anything as to that, I wouldn't speak as to what happened, but if you want to talk about your bond, you may.
Judge, I think part of Mr. Ramirez's conduct is that he does go to counseling frequently, and he does, as the court's now aware, he does smoke marijuana. I think part of this behavior is because of his mental health. I think that's a part of this issue. I don't think sending him into custody would particularly help that issue. Of course, if we put him on pretrial services, having conditions to perhaps attend counseling, frequent drug tests, I think that would remedy the issue more than increasing his bond and putting him in custody.
Very well. I mean, I don't know what else you're using in addition to THC, but I don't know that because I've asked you to go and take a test and you didn't take it. So that is one of the conditions of your bond, is to stay clean while you are on. Setting aside the THC, again, you failed to comply with giving a test. So the court's going to increase your bond. It will be $17,500. That's a cash surety bond. When you get out, you must report within 24 hours to pretrial services. They will now take oversight of your case. They are there to help you. That's why this whole system was set up through them. So if counseling is something that you need and you need in the meantime, let them know about that. Okay, that is their role. But what we want to do is make sure that you're getting the help that you need prior to us moving forward with your case. That will still proceed, but in the meantime, they can help you. Understood? Do you have a job?
I actually hit 3 weeks last week. I mean, 3 years last week.
Okay, what is your job?
I work at Amazon Fulfillment Center.
Okay. Well, you'll need to show proof to pretrial services that you are going to your job on regular time.
I work overtime ever since this. I hit 3 years at that. It's like a slave. So I work there. Try to like. I don't really want to be there, but yeah.
Well, I'm proud of you for working. Yeah. And
Yeah,
I
I know.
don't want you to, but circumstances here dictate that we have to change what the setup is, okay? All right, so we'll just have your setting. Becky has the next setting and we'll come back at that time. If you get out, make sure that you are not using. Now, I want to ask you about the THC. When was the last time you used THC?
Probably yesterday.
Yesterday?
Probably yesterday. I'm like, you know, I know he advised me not to speak.
No.
Talk
I
about
think
the bond right now.
Look, he's looking out for
I
you.
know,
The
I
reason
know.
I asked that question is because I want to know, going forward now, you understand that you cannot use THC,
I know.
right? And in 30 days, your system will be cleaned out. But if in 30 days, in 31, 32, you test positive again, that means that you've been using again. Do you understand?
I understand.
Okay. So, and they will do frequent random testing when you get out. And so they can call you up at any time. I don't want it to interfere with work, but it may sometimes. And if it does, you need to come in and give a test. Failure to give that test could indicate that, or would be a violation of the order as well. Understood?
I understood.
Okay. All right. Good luck to you, sir.
Thank you, Judge.
Thank you.
They're going to bring up Jabari McGilvery. The
Okay.
interpreter has to leave about 25 minutes ago. She needed to go. She was only there for 2 hours.
Okay.
So they're going to bring him up right now.
We'll do it first thing.
As soon as he's up.
Okay.
Okay.
All right.
She's
No
got
problem.
she has to get to the.
Okay. All right, Mr. Brown, is your client here? What are we doing, a plea?
Yes.
Morning, sir. How are you?
I'm doing all right.
Good.
Okay. Yes.
Tell me your name, please.
Daryl Lee Ellison.
Ellison.
Yes, sir. How you been doing today?
Good. How are you?
Trying to make it. I'm sure.
Ruby, are you ready?
Yes.
Okay. You don't go in too fast. I'm aware. Court call CR 24-2177F, the state of Texas versus Daryl Lee Ellison. Can counsel please make their announcements for the record?
Philip Hebert for the state.
Can move around to the defendant, Daryl Lee Ellison.
And are you the same Daryl Ellison who in CR 24-2177F is charged with evading arrest with a previous conviction?
Yes, sir.
I have paperwork here that indicates that you would like to enter into a plea bargain agreement on this charge. It's a state jail felony. State, what's the range of punishment?
Judge, normally it would be not less than 180 days in jail, not more than 2 years, but we're proceeding under a 1244A agreement, which changes the range.
Okay, what I need you to know is, as charged, do you understand that that is the range of punishment that you face between 180 years in the state, 180 days, and 2 years in the state jail facility? you understand that?
Yes, sir.
All right. According to your, I'm sorry, what I'm showing you here are the written admonishments, the stipulation of evidence, and the waiver of rights. Did you go through this packet with your attorney and discuss its contents?
Yes, sir.
On page 4, there's a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you would be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir.
Is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied the state fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Ellison is competent to enter into this plea today?
I am, Your Honor.
The reason we talk about evidence is because you have the right to know what the evidence is against you. Did you discuss that evidence with your attorney?
Yes, sir.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, sir.
According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend 90 days in the Texas Department of, in the Hayes County Jail and credit for time served. Does it say anywhere on here that you're proceeding under 1244?
Judge, there, and then based on the box that we check, I think on the 3rd page of the plea deal, talks about the punishment range. And then on the judgment, it says that we are proceeding as a state jail felony punished under 1244A. It's the one that has the boxes.
I think he's
Is there anywhere on the plea bargain agreement that says we're proceeding on 1244A?
Judge, I was told that it was not necessary, and that saying 90 days in the Hayes County Jail was enough on the plea bargain agreement for that to be made known. I can write in something, and going forward,
Let's
I
write
can
that in just so that
make
everyone's
note of
aware of what
that.
we're doing. I'm not
Sure.
Arguing with the information that you have there, but that way it's real clear to him. So what I understand is that you want to proceed on a 1244A. Did you discuss what that means with your attorney?
Yes, sir.
You'll be sentenced as if this were a you will receive misdemeanor punishment.
Yes, sir.
You understand that?
Your Honor, I would like to add, he has a misdemeanor case. It's CR 24, 1713 CR-3, and that misdemeanor case will be dismissed pursuant to this plea. So he may need to fill in that number on the state to dismiss.
Okay, you guys can sort that out. I don't know about that case. Well, is it your understanding that another case is going to be dismissed as part of your agreement here? Okay.
Yes, sir.
Do you understand that you will be sentenced in the Hayes County Jail for 90 days? You understand that?
You need to say yes.
Yes, sir. Yes,
Okay.
sir.
And is that how, under this agreement, you would like to proceed?
Yes, sir.
To the charge of evading arrest with a previous conviction, how do you plead?
Good.
Are you pleading guilty because you are guilty,
Yes,
for
sir.
no other reason? Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt. Is there any legal reason we can't proceed to sentence you?
None from the defense, Your Honor.
Any state in the argument?
Judge, just that you follow the plea agreement.
Defense? Any argument?
Well, I'm asking you to follow the plea agreement.
Very good. Having found that there is sufficient evidence to substantiate your guilt, the court now sentences you to 90 days in the Hayes County Jail pursuant to 1244A, you will get the credit for the time that you have served. Anything else we need to take up?
No, Your Honor.
All right,
No, Your Honor.
sir, I have followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and that will be added to your file. Looks like you'll get out soon. Take care of yourself, all right?
Thank you.
All right, try to follow the laws.
All right.
Good luck.
We'll get you right down.
Let's go on that McGilvery case.
So I'm done with 1244.
Yeah. Time
So
to-
so I'm done with Hayes County.
What about it? 17,500. Yes. McGilvery. Sir, can you approach, please? Sorry?
Just the captures. If you put the. Thanks.
Morning, sir.
So that I can interpret.
Yes.
Okay.
Oh,
perfect.
I
Thank you.
apologize.
That's okay. That's great. Thank you. And would you like to swear me in, Your Honor?
I will when we get on the record.
Okay, great.
What are we doing here on this case? Strategies, what are we doing?
Your Honor, the state has made an offer to me that, let me put it to you this way, it involves resolving some new cases he has. I received the discovery on those cases after we left court 2 weeks ago today. I am still in the process of reviewing that material, and Mr. McGilvery would like to review some of that material with me before he decides whether to accept or reject the state's offer. I am right now asking for more time.
Very good. We'll do 3 weeks. That's the next time we have a setting that is available. Longer than the 2 weeks, give you just a little more time.
Thank you, Your Honor.
Yes, sir.
For the record, am I being live streamed or video recorded?
You are not, because the recording went off.
Thank you.
However, it may be coming up that your voice is being heard.
I object to any such recordings of myself in this courtroom on behalf of myself, my clients, and on behalf of the dignity of the court. And that goes for today, and that goes for the future.
Hey, sir. Yes.
I have given a copy to postal council on this, Your Honor.
Steve, do you know who these people are?
I do not.
Can I give you some background information?
Yes.
Okay, on the second one, Mr. Melendez, Your Honor, my understanding is that Ms. Hanson spoke with Mr. Watt earlier today after I had finished this.
Wait, who spoke with him?
Ms. Courtney Hanson, she's
Okay.
also a prosecutor,
Yes.
spoke with Mr. Watts, and she informed Mr. Watts that as far as Mr. Melendez, the second individual on that list, that he had been subpoenaed, was served an hour after we had served him. So, and he had inquired as to whether or not he needed to be here. My understanding is the investigator for the district attorney's office told him that, hey, that's completely up to you, but this is when you have to be here, which would be next week.
Okay.
So, but Mr. Melendez is not here. My understanding is not been served by both sides. I think now he might be here, but we still have him as far as on this writ of attachment because he was not here this morning as the subpoena had indicated him to be. Mr. Melendez, as far as background information, Your Honor, was the lead or the first responding officer to the scene and had lengthy communication from my client as to what had transpired that day. The first witness, Mr. Eugenio Chavarria, Your Honor, he was a witness and lived in the apartment complex who heard, or it's alleged that he heard kind of what transpired prior to the discharge of the firearm, Your Honor. So that's why he would be material and necessary in this case, Judge.
Steve?
And I'm sorry, who was it that you said our investigator spoke to?
The second one.
That's an officer.
Melendez.
Melendez?
He's the former officer, Your Honor. He was with the police department. Now he's no longer employed with them, Judge.
Judge, I'm a little concerned if Mr. Melendez did reach out to at least one of the parties that he had been subpoenaed by, and received some conflicting information about when he needed to be present. I would ask that we give him an opportunity to have some clarity on that. I will instruct my people regarding that as well. I'm a little uncomfortable giving that he did reach out and make some efforts and may have gotten some bad information, issuing a writ of attachment for him.
And I just want to be clear, Judge, he did not reach out. My understanding is when the detectives went to serve him, from the DA's office, when to go serve him, an hour after he had gotten our subpoena, that's when they communicated. So the communication was initiated by the detective from the DA's office going over there serving the subpoena, Your Honor. So Mr. Melendez did not reach out. However, I do believe that if he's given enough time and told kind of what the consequences are, that he'd probably be in compliance now that he knows that both the DA's office and ourselves have subpoenaed him.
So you were withdrawing your request to attach Melendez?
Can we hold that one maybe till this afternoon, give them an opportunity to confirm, Judge? Because I don't want to withdraw the request and then he doesn't show up. And what we're trying to do, Judge, we're trying to make sure that we've done everything possible to make sure that these witnesses are here. The last time they weren't here, and we don't want to be in a position where like we're coming before the court asking for a continuance when we have not used all due diligence to try to get them here, Judge.
Fair enough. So can you be in touch with Ms. Hanson and see what the status is?
Judge, I know about this case. Melendez has been served and plans on being here next week.
Okay.
Without representation, Your Honor? Of course, if he's not, then we're going to be back at this page. We would withdraw that one, Judge, but.
Where does he live?
He lives in Dell, here in Hayes County, Your Honor. He's a local resident.
Okay, so it's like the other guy's in Midland.
Yes, Your Honor, Midland County. And the other thing is that information with regards to Midland County is information that we gained through our own investigative means. The district attorney's office have provided some other information with regards to him. And specifically, they have provided two addresses. One, it was the 1011 Wonder World Drive, San Marcos, Texas, 78666. That was at the apartment complex where everything transpired. Another address that they put as new was 112 Westminster Drive, Cal, Texas, 78640. Both of those addresses were not are not good. So we hired a detective and we were able to trace him down to Midland where he was properly served, Your Honor. Okay. And he was actually served back on August the 2nd. So he's had more than enough time to reach out to us, Judge. Furthermore, with regards to Mr. Chavarria, I have 3 different phone numbers where I've called and left messages. I've also have 2 different email addresses where I've called and or I'm sent email messages to, Your Honor. So we've been trying to get him to respond. For Your Honor. More specifically, Your Honor, if you look at 2405 is with regards to refusing to obey the subpoena. 2406 is what disobeying means. And then in 2411 is when you get to the attachment, Your Honor.
Judge, we have been in contact with Mr. Chavarria as well, and he did have a new baby a week ago.
And may I ask when we are in contact with him?
I don't know, step back and discuss those things.
Thank you,
I mean, I want to, you know, if the state believes that he's going to be here, I'd like to know that. If you have information, you know, we're taking a big step to do a writ of him. And so I want to not have to if it's not necessary.
So do we, Judge. The only thing I just want to make sure that we've done everything. If we have to come back and say that, Judge, they're not here, that you know we've exercised that diligence.
Yeah, no, I understand. You're doing your job.
Thank you, Judge.
Hello, Mr. Campbell.
Brochure?
Yes, sir.
We're ready for plea on Gilbert Moran.
Moran, all right. Ms. Moran, can you approach?
This one is actually named initials. We're not on YouTube this morning.
Well, we were, I made the announcement at the beginning, but the computer just restarted. And so I don't know if it's going anymore. It appears to me that it's not, but if I were to mislead anyone, I
I'm
would,
just making conversation.
yeah. Well, I want you to know,
Yeah.
I mean, that says that it is, but that says that it was turned off because the computer just did an automatic restart. But I don't want to, I think, assume that it is, even though I don't think that it is, but kind of the guys that run that haven't been in here to look at it.
I'll watch myself.
That's right. Nicholas Acuna? Oh, and that's a McCray case?
Yes.
Has he discussed it? Does he know about it?
Yes.
Okay. Court calls CR 23-5055, State of Texas versus Gilbert Marine. Can council please make their announcements for the record?
Allison Boost for the state.
Phil Campbell for the defense.
Are you the same Gilbert Maureen who in CR 23-5055F is charged with possession of a controlled substance with intent to deliver cocaine, 4 grams or more, but less than 200 grams? Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, if you can, what I want to ask you to do is wait until I've finished,
Okay.
and then you can respond. Just because she's taken down everything we say, we want her to be able to make a clear record.
Sounds good.
And also to just speak up and project so that she hears everything. Okay? Your charge here is a first-degree felony. State, what is the range of punishment for that charge?
Not less than 5 years, no more than 99 years or life, and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for this charge?
Yes, sir.
I have paperwork here that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir, I have.
On page 3, there's information. On page 4, there's also information that is a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on page 6 of
Yes,
the
sir.
chart? Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea. You can proceed as if this didn't happen. You don't have to plead. Understand that?
Yes, sir.
You don't have to plead at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir, I do.
Understanding those rights, do you still wish to proceed with this plea agreement? You
Yes, sir.
understand? You understand all those rights I just told you?
Yes,
You're
sir.
going to waive those to enter into this plea agreement. Understand
sir.
that?
Yes, sir.
And do you want to waive those rights and enter into this plea agreement?
What there's, you want to give up certain constitutional rights like the right to remain silent and so forth, to enter this program.
Oh, yes, sir.
Okay. Are you a citizen of the United States?
Yes, sir, I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duties to give you evidence under Article 3914. Are you satisfied that the state fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Maureen is competent to enter into this plea today?
That is my belief.
The reason we talk about the evidence is because you have the right to know what the evidence is against you. Did you discuss that evidence with your attorney?
Yes, sir.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Throughout this whole situation?
What's that?
Or like, you mean throughout this whole situation?
Yes.
Yes, sir.
Very good. According to your plea bargain agreement, in exchange for your plea of guilty to the charge, the state will recommend 10 years deferred adjudication. There will be a fine, restitution, fee, and evaluation and community service. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of possession of a controlled substance with intent to deliver cocaine, 4 grams or more, but less than 200 grams. How do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Because I know.
I'm sorry?
Because I know I am. Yes, sir.
Very good. Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. What I'm going to do is order a PSI. That means someone from probation will speak to you. After they've spoken to you, they'll prepare me a report, and we'll come back at a future date and do your sentencing.
Yes, sir.
Understand?
Well, definitely.
Very good.
Thank you, sir.
Make sure that you cooperate with probation when they speak to you.
Yes, sir, I will.
All right.
Thank you.
Sir.
Thank you.
Thank you.
Yes, sir.
All right.
May we reapproach, Judge?
Yes.
We have Ms. Cordova again.
What do we want to do?
She understands that you are almost certainly going to not accept the plea bargain and give her a probation. We're going to go forward with that. Once that's assessed, I think most likely she's going to accept that, and we're going to go downstairs and plead out her misdemeanors.
Okay, very good. So I'm going to order a PSI, and then we're going to come back and do a sentencing at a future date.
I understand, Judge. We explain that possibility to her.
Okay, very good. Court call CR 23-5901F, the state of Texas versus Priscilla Cordova. Can counsel make their announcements for the record?
Allison Booth for the state.
James Winters for the defense.
And are you the same Priscilla Cordova who in CR 23-5901F is charged with possession of a controlled substance, methamphetamine, less than 1 gram?
Yes, sir. Yes, Your Honor.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes. Yes, sir.
That charge is a state jail felony. State, what's the range of punishment?
For state jail felony, it's not less than 180 days in jail, no more than 2 years in state jail.
Do you understand that that is the range of punishment that you face for this charge?
Yes, sir. Yes, Your Honor.
I'm showing you what is marked as the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you'd be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
This is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied the state fulfilled that obligation?
I am.
And do you believe that your client is competent to enter into this plea today?
I do.
The reason we talk about this evidence is because you have the right to know the evidence against you. Did you discuss that evidence with your attorney?
Yes, sir.
And do you believe your attorney has provided you effective assistance of counsel during the course of this case?
Yes, sir. He's an awesome attorney.
He's an awesome attorney, is that what you said?
Yeah.
Very good.
Thank you.
According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend 240 days in the state jail facility. You will get credit for the time you have served in the amount of 177 days. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of possession of a controlled substance, methamphetamine, less than 1 gram, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, I'm guilty.
Based on the stipulation of evidence, based on your plea, I find that there is sufficient evidence to substantiate your guilt. But I'm not going to make any determinations beyond that at this time. I'm going to order a PSI. We'll come back at a future date and do your sentencing. What a PSI means is that someone from probation will come and speak to you, make sure that you cooperate with them so that they give me a full report.
Yes, sir.
All right,
Thank you
very
so
much.
much.
All right, thank you, Judge.
Thank you.
We'll see you in about a month, 6 weeks. I'm not sure how long.
Coordinator, I'll let you know.
Okay.
Thank
Judge.
you.
Thank you.
I just saw you one. What did you say? Yeah. May I approach on an update on that Tommy Lee Garcia on page 3?
Yes.
So, Your Honor, we spoke with the defendant, and it looks like he's done some things that we weren't notified of by Travis County. We have.
Come on up, Mr. Garcia. All right, you spoke to probation for me?
Yes, sir.
Thank you very much. So what's our status?
So basically, we have requested an updated progress report from Travis County so that they can give us indication about where he's at now. From the defendant, we've learned that he's done some community service. As far as the intensive outpatient program, they're waiting to re-refer him for the results of this hearing. So
What does that mean?
that just means that they didn't re-refer, when he didn't go to IOP, they didn't refer him back because they didn't know if he was gonna go to SMART program or be continued in IOP. So they're prepared to go either direction.
Okay, so have we seen something that indicates that he's not following his terms?
We are waiting on that progress report. We were hoping that they would get that to us timely, but it is Travis County, so I'm not sure how long it takes them to respond.
Judge, I actually have the progress
Did
report.
they? Oh,
Yes.
Okay, go step back and take a look at
Sorry.
it. That's all right. Go look at it and see what you need to let me know. All right, let's run through anyone else.
I just need a clarification on this one since I'm doing the writ. When you guys recently, had asked for this kind of served to be concurrent with another theft case, but I didn't.
You don't know the test case number? Yeah, I don't either. Say, you know that number?
I'm sorry, I was not even listening.
Pastrana.
Pastrana.
I had 2 more people that were invited but didn't show up. You said you were gonna run through it, so. Page 1, Samuel Ariola.
Yeah, so I think that Becky's handling that one. He's in another one. What's that?
He's in TDCJ.
Okay.
Okay, so he has a previous engagement, and then the last page. Miles Williams.
He gave a waiver just to the.
Okay, that was it then.
Ma'am, what's your name? Yes, I'm sorry? And which case you here on? Okay,
His mother.
very good. You're welcome to be here, is what I mean, not you're welcome for anything. But welcome to be here. In the back row. Back row.
Ma'am, what are you here for? Is he here?
What's your name? Jasmine Richards.
Thank you.
Go ahead, Stevie. What's the status of, on that page, Becky? 6 Renteria Rios.
Jesus Renteria Rios with Kyle Ernst.
Was what?
Kyle Ernst hasn't been here on Renteria.
Renteria Rios? Oh, very good. Have you heard from your attorney?
Listen, I called him today at 8 a.m. I'm just been trying to call him. Is he gonna go take the voicemail?
And what's that?
Is he gonna take the voicemail?
Okay, hold on just a moment. And we'll try to figure out where he is.
Okay.
Then Jasmine Richard. Augustine Schulke,
Called them 3 times, I think.
called him 3 times. Can someone tell me what his bonds are? This is the one yesterday that Will Hill said would be here. Did you call Paul Tompkins 3 times?
I've not called any names yet, because I want to get the whole list before I did.
Okay. Schulke, Tompkins.
For CR 22-1209, I have $100 cash bond.
$100 cash bond on which one?
For CR 22-1209.
Okay. And then on the,
The second one?
yes.
Same thing, $100 cash bond.
All right.
22-4115.
Have you heard from Mr. Schulke? Schulke does? Okay. Yes.
These are the conditions for that manual.
Okay, but, one with the little contraption.
Right. If he didn't sign it, is it okay? Should I go to the top?
We need to sign it so that we can hold him responsible for it. Thank you, ma'am. Hello, sir, what's your name? I'm sorry? Chris what? Bart? Ibarra. Oh, okay. You're free to be here. Did I sign the arraignment on Elijah Ellaby? Did I sign that one? On page 2?
No, Mr. Jones has not been here. No, we have Medina, Ellison, Williams. Being those three on the waivers I have.
Okay. Mr. Evans, do you have Jose Duran?
Yes, sure.
Are we bringing him up?
That was the plan, right? I don't know.
Although it's just an
Where I
arraignment.
can't have him brought up.
Well, it's just an arraignment. I don't have to bring him up for that.
Well, I'd like to have him arraigned.
Oh, okay. You're not gonna do a waiver? Very good. Bring him up, please.
Yes, sir.
Your Honor, we have not had contact with Schulke.
Okay.
I called the name 3 times. There was no response.
Increase the bond, please, in both cases to 4,000.
4,000 each.
Yes.
I called the name Paul Tompkins at 12 o'clock. There was no response.
Do you know his previous bond was?
I don't remember previous, but you said it at 25 this time.
Very good. Lord.
And I will do those as soon as you step off the bench.
Okay. Cunha State, have you all been able to talk to defense counsel on that one?
Which one?
On Acuna? Or is anyone?
Judge, I did talk to Leland about it earlier today. He said he did not know of this client.
It looks like he's in custody.
I think then Leland might be in another courtroom, dealing with a trial docket over there. I think he probably plans on doing this.
Okay.
So,
Did you get any word, Becky, on that one?
They asked me for a reason, I told them no.
Okay.
When you're like, I was confused, and you're like, I don't know how I can make that. It's literally a one-word response.
Elodie and Duran then are on page 2. Any word from Richard Jones?
No, the last I heard was 11 o'clock. And he let another court know, and I told them to let him know he has a case over here.
Okay. Do we think he's in the building?
I did just see Mr. Evans in 5.
I don't know if he's in the building. I don't know.
Oh, Mr. Evans is right there. Okay, Garcia. Leave. Garcia, leave.
For you, Judge.
Yeah.
You what?
He was sent for a drug test as he hasn't had one since about April.
Okay, good. Yes.
Much to do about nothing, Judge.
Yeah.
It appears that the DA's office has spoken with both of them. They plan on being here, Judge.
Okay.
So as far as that request, just hold it until Monday if need be. Otherwise, we just won't urge it if that's okay with the court.
That's fine. Are you calling either of those in your case, Chief?
We're calling both of them.
Okay.
So.
All right. Well,
Okay. Well, there we go.
There we go. All right.
Thank you, Judge.
Thank you. All right, so we'll see you on Monday, and you guys are, I think, our own case. Well,
You got two,
We've got-
Spear and this.
what's that? Spear,
Spear
that's
and
right.
King.
Spear announced, or defense announced not ready on that one.
So they don't have a motion.
But yeah,
We're going.
sounds good.
But you're,
And I'm confident this one will be going, so.
And Judge,
just looking for my list, just like.
around what time do you want us here, Judge?
So we'll. Jury comes at 8, or I should start at 8:45. So I'll do qualifications, should be done by 9:15 with that. You can be here for qualifications if you'd like, or 9:15 is when we take up anything that needs to be taken out of. If there's anything before trial that y'all think needs to be taken out, let me know. And then we start picking, my goal to start picking at 9:30.
And Judge, just so you know, that'll be Courtney Hanson and myself.
Okay.
So.
Who's the?
Courtney.
Okay.
And Your Honor, as far as starting testimony, do you start on Mondays or you start on
Mondays, yeah.
Monday afternoon?
So we'll start Monday afternoon. Particularly because that next, that weekend after.
Yes, sir.
Is a, right, 3-day weekend, so I don't want to, we'll be pushing to finish next week so that jurors aren't coming back after. a long weekend.
The other thing, Judge, we have one witness who was from out of state that we had previously, they've accommodated us. And Judge Seal might have noted in this docket, or he told me that I could tell the judge that we'll probably have her here on Wednesday, Judge.
Okay.
So I just want to let you know that that's one of the defense witnesses we might have on Wednesday. You're saying you're 3 days. We'll probably be okay with that. It's just.
I think, yeah, you'd probably start on Wednesday.
Morning.
Maybe afternoon. So
yeah, I think maybe
there's some
maybe morning. Get them here.
Yeah.
Okay.
Yeah.
Just,
there's some videos that we'll have to watch. So it's,
yes,
an hour I think is the longest.
The longest one is like an hour and 30 minutes.
30, yeah, but not too much.
An hour and 30 or 30 minutes?
An hour
and 30.
Are you going to show the whole thing?
I think so. Yeah. But
okay.
Only 2 or 3 videos, so it's not like we're just going to be 8 hours of video or anything.
Very good.
But yeah,
if y'all need to talk about those videos, make sure you confer in advance.
And do redactions
any
and all that.
redactions
Yes,
that you need. Okay.
Great.
Yes.
Yes.
Thank you very much.
Thank you. Thank you.
We ready on Mr. Duran?
Yes, Your Honor, we're ready to have the room.
Mr. Duran? How you doing, sir?
Good, sir.
Good. We can put it on there. Court call CR 24-2113F, State of Texas versus Jose Refugio Duran Jr. Can counsel please make their announcements for the record?
Allison Boost for the state.
Paul Evans on behalf of the defendant, and I would note that if we are being video recorded or live streamed at this moment, I object to that on behalf of myself and on behalf of Mr. Jerome.
Okay. Objections noted. I've told you that I am unclear whether it is, but you should assume that you are being live streamed right now.
And that is being done without my consent.
Tell me where your authority is that you give consent.
Well, Your Honor, unfortunately, the criminal courts of Texas have not adopted Rule of Civil Procedure 18C. I would note that the neighboring Rule of Civil Procedure 18C has a neighbor 18B, which deals with recusal of judges, and that was explicitly adopted in criminal cases by the Court of Criminal Appeals not long after its enactment. I don't recall the case site off the top of my head, Your Honor. I do know that that opinion embracing the 18B rule was authored by Michael McCormick, who is at that time the presiding officer of the Court of Criminal Appeals, a position to which he was duly elected. I would note that the 18C Rule of Civil Procedure does not require a party who does not consent to video recording to state or express the reason for their lack of consent, in much the same way that a complainant in a sexual assault case in Texas is not required to explain why the complainant did not consent to being sexually assaulted. Perhaps one day the courts of Texas will embrace these rules in our criminal courts, as I believe that, you know, it's strange how in civil cases there are clear rules where the parties can object and say, hey, I don't consent to that, where only money is at issue, yet where a gentleman's freedom is at issue, his liberty is at stake, there are no such rules in place. In the absence of that firm authority, I am objecting. I am objecting vehemently. I'm objecting strenuously, taking language from Rule 18C. This is a distraction. The proof is manifest right here. The fact that we're taking up valuable time in a courtroom in a county with clogged dockets and clogged jails, that we're even discussing this. I object.
Objection is noted. I think at the end of all that, what I've heard is there is no authority under the criminal code or under any criminal laws of Texas that require consent. Is that what I'm hearing?
I'm here on Mr. Duran's case, Your Honor.
I'm just
Let's
asking.
proceed.
No. You just made an argument, and I'm trying to understand your argument.
Yes.
Your argument is that it is.
And you are making an observation to me that you don't care what my argument is. You are just gleaning the fact that you can do it and you can get away with it. And that's that.
I'm asking.
We're here to arraign Mr. Duran, and I'm asking to have Mr. Duran arraigned so that I can go tend to other business in other courtrooms.
I'm asking you if there's any authority, because I'm listening to your objection. Do you want me to?
I couldn't find any, Judge. I looked for it.
Okay, but then that's all you have to say.
Okay.
Now, as far as the distraction, I don't believe it's a distraction to the extent that people make it a distraction. It has not affected the way the court has handled things. And as far as the suggestion that there is a clogged docket and this causes or further clogging of the docket, I disagree with that. This court is sufficiently moving its docket.
Your disagreement is duly noted. May we move along with this arraignment, sir?
So we're here today for your arraignment. The grand jury returned the following. In the name and by the authority of the state of Texas, the grand jury presented to the 453rd District Court of Hays County, Texas, the following charge. On or about the 17th day of May 2024 in Hayes County, Texas, you, Jose Refugio Duran Jr., did then and there intentionally or knowingly possess a controlled substance, namely delta-9 tetrahydrocannabinol, in an amount by aggregate weight, including any adulterants or dilutants of 1 gram or more, but less than 4 grams. That was against the peace and dignity of the state. It was signed on July 17, 2024 by the grand jury foreperson. To that charge, how do you plead?
Not guilty.
Very well. I will make a note of that in the docket of the court, and we'll come back for a setting at a future date.
You know the date?
We'll get it for you in a second.
All right, we're off the record.
Have you excused?
Looks like it. Hello, Mr. Daniels. Thank you for being here. What do you have?
Jasmine Richards, Your Honor.
Okay.
You might recall, she had previous counsel. This is only my second time here with her. I'd like to
Ms.
ask
Richard, can you approach, please?
if we could have one more reset. She had previous counsel who I think became a prosecutor and had to be.
Very good. You were here on time today. Thank you very much. If we were to send you down for a test right now, would you be clean?
Yes.
All right, very good.
I'm supposed to go to one after a court meeting.
You're supposed to go after court today?
Yes.
All right, very good. All right, we'll do one more pre-trial setting. After that, we will move this case to a plea setting. That does not mean that you have to plead, but if there is no agreement, then the setting after that would be a trial setting. That's still 90 days off. I just want you to understand how the court will possess on your schedule. Very well.
Thank you.
Okay, thank you. Y'all have a good day.
Don't go till I give you the new reset.
All right. Yes. Have you been over this report with them? Yeah. Ruby? Acuna, the first one. Court calls CR 23-4450F, the state of Texas versus Nicholas Jesus Acuna. Can counsel make their announcements for the record?
Allison Boost for the state.
Leland McCray, the address of Kuna, just to my left.
Mr. Acuna, are you the same person who pleaded guilty to possession of a controlled substance, cocaine, 4 grams or more, but less than 200 grams, and also pleaded guilty to retaliation?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Sir.
All right. Sir, we are here today for your sentencing. I have received a PSI report from the probation department. Counsel, have you had the opportunity to review that report and discuss it with your client?
Yes.
Are there any corrections or modifications to the contents of that report?
No material on Judge. We just asked the court to adopt the plea bargain.
Is there any legal reason we can't proceed to sentencing?
No.
State?
No,
Any argument from the state?
none.
Defense?
No.
Having found that there was sufficient evidence to substantiate your guilt, I did not make a finding of guilt, and at this time, I grant your application for deferred adjudication
there will be a $500 fine, $288 restitution. You'll pay supervision fee. You will do 400 hours of community service. You will have no contact with Joe Malicia, Corina Rodriguez, or Ray Sines Jr. Do you know who those people are?
Yeah.
Okay, here's the thing, the reason I'm asking, it's not to put you on the spot, but for you to understand that you're not going to have contact with them, I have to ask you if you know who those people are.
Yeah.
Okay, so for the next 10 years, while you are on probation, you won't have contact with Joe Malicia, Corina Rodriguez, or Ray Sines Jr. Do you understand that?
Yes, sir.
Okay. You will not possess any firearms during the course of this probation. Do you understand that?
Yes, sir.
You will do the drug offender education program. You will do frequent random UAs. Do you have a diploma, sir?
No, sir.
Do you have a GED?
Yes, sir.
You do? Okay, very good. You'll do the moral recognition therapy course. I think that's a good one for you. You will be under the specialized caseload for MH. You will have intensive supervision. Do you have a job?
Or not at the moment.
Not at the moment. You've been in custody. I understand that. Did you have one before?
No, sir.
No, sir?
Nope.
Okay. What can you do?
Everything.
Yeah?
Construction, everything, modeling.
Okay.
Cook, I was doing everything.
Okay, very good. What I want you to do is register with the Texas Workforce Commission, and you need to show evidence to the probation that you have registered with them and that you are applying for at least 3 jobs per week until you get a job. Hopefully it won't take that long. If you can do as many things as you want, people are going to want you, right?
Yes, sir.
Good, I hope so. And lastly, based on that retaliation case, you will submit an apology letter to the arresting officer. Do you understand that was part of your agreement? Okay, you're gonna do that? Do you apologize to that arresting officer?
Yes, sir.
All right, very good. Well, I appreciate it. What's your plan going forward? You're getting out very soon and you're gonna be. What's that?
Get a job. Well, I had just recently lost my mother, so I was gonna see so as far as going to graveside or whatnot, it's in Oklahoma.
Okay.
I was gonna see if I could go visit down there, just for like a day, 2 days, just to see my mother's grave because I haven't been able to see her.
Okay. I think that should be able to be worked out with probation. Talk to them about it and make sure they know when you're going.
Yes, sir.
All right. But, understand this is an opportunity for you. You've got deferred adjudication. That means that if you complete successfully, you may not have this on your record. Otherwise, if you don't complete it with a 2nd-degree felony, you face up to 20 years in the Texas Department of Criminal Justice. You understand that?
Mm-hmm.
So the opportunity is all yours now. You can go and take your life in the direction you want it to. I hope it's positive and you get a job and you do really well, Mr.
Sure.
Okay? Good luck to you. Let me just add this. I have followed your plea bargain agreement, sir. Because I have followed your plea bargain agreement, you do not have a right of appeal. And I'm signing the trial court certification that will be added to your
Right
file.
from that one, straight up, straight down.
Anything else you can take up?
Straight down.
No, I've got it. Not in this matter.
He's on.
One more
it.
time.
He's on it.
Okay.
Yeah,
You're good.
He should be here.
There you go.
That's for sign, right?
Right. You got the paperwork. to go.
Yes.
Oh, whoa. Mr. Garcia, did you get a result?
Okay, thank you.
Yeah, he did not.
Negative?
Yes.
Good. Good job. That's good. All right, so let's talk about what you think needs to be done at this point.
I think he should be allowed to do IOP. And let's just tell him to get it done and give him a timeline maybe.
Okay.
And we could revisit it if we need to at a further date.
All right, so you understand, originally it was that they were gonna put you in a SMART program, which means that you would go into an inpatient. Now this allows you to be out in the free world.
Yes, sir.
Is that what you prefer to do?
I did just because I got I've been fighting custody with my daughter, and I finally got custody over for every other weekend.
Okay.
So that's why I didn't want to go to the SMART program.
Okay.
Because I'm about to get her now. So.
All right. So understanding that, are are you gonna be able to make it to all of your meetings fee that they're gonna
Yes, I'll have
find
to.
for you?
Yes, sir.
Okay, great.
Yeah.
Well, I want you to do that, and they'll give us updates if there's anything that's going wrong, but, you know, now if you've got your daughter, it seems like you've got some real reasons to be taking care of things.
Yes, for
Yeah?
sure, yeah.
All right, well, good
Trust
luck
me,
to you.
yeah. Thank you.
Thank you. You need to talk to him
Yeah.
anymore? Okay. Do we know anything more on the? What's that front row? Right there.
I have not heard anything additional from Kyle Ernst. Mr. Renteria, I believe.
Anything from Kyle?
Not he called. I think he let Cindy know that he was going to be running late, but he has not appeared for any court.
Okay.
Sound like he knew about this case.
It sounds like he did not.
No, because he only contacted Cindy about Judge Judy's docket.
State, I'm gonna ask you for information that you think would be helpful to know about on that motion to adjudicate.
Let me
I
pull it
don't
up.
have the motion before me. Are you ready?
Yes.
All right. I'm sorry? Okay, Mr. Sines, coming up, please. You want to try that down there?
I don't believe so.
You have one of the pools too, right? Yeah. We appreciate your hard work for the clients. You had a good attorney on this case. It's hard for you. Duncan.
Sir.
Back on the back left, what is that case?
They are here for your son.
I need like 3 parts to sign, but I only need 2 pages for it.
I'll have to ask their family members or somebody coming up from downstairs.
Okay. All right. Yeah, let me know.
Well,
I mean, have we not brought them up yet?
I have
No.
to sign and seal, because it's 3 parts.
Well, I'm guessing we're not going to then at this point. Unless it's-
The only other case is Amy Walker. And I believe Mr. Brown left.
We never get, she's been gone for a long time, right?
She just got back to Georgia.
I think I picked her up in Travis County.
Can we call?
I don't have anyone to make the call. I asked, and there's only one person in the office right now. Everyone else is in court. So he left the building, he's not in anyone else's court, that much I got. So he's gone.
She's in custody, right?
Yes.
Do you mind stepping out and making the call?
It's 2 number 3.
Elevate.
Yes.
Mr. Jones came in, did he go downstairs to get a waiver?
He did.
Okay. Does he want to do an arraignment?
Shockingly enough, no.
Make the show?
Mr. Jones isn't really kind of a showy guy. Oh, he was one of my first story trials after COVID in Comal County, and we did make it a point during board ire to explain he does not have COVID. He has tested. He had this cough pre-COVID. This is just Richard Jones. Because you could see the jurors were like scooting back as soon as he started coughing.
He looks hard. For signs, I do not have. Here's the murder one, but
do you have the file for this case?
We just had to refile the motion to adjudicate, so they may not have given it to
Okay.
Yeah,
you.
we have to be brought up. We did it all today.
Yeah, so
For 1 second, just have to get the case number and have them bring it up.
You have the,
violation notice on Mr. Interiorius.
do you have the, are you able to bring up the paperwork on the aggravated assault on this case?
Yes. Is there specific paperwork you're wanting?
I just want that front page to see what we, or the sentence or anything. I mean, I'd look at the judgment too. If I had my file, I'd look at all of those to see what he was sentenced to at that time.
Well, his judgment has the date of the original and the length of supervision. That's part of that judgment. But I could also print the order of deferred if you would like.
No, that's okay. So he originally got deferred for how long?
3 years.
On ag assault.
Correct.
Are we ready? All right.
I already have somebody bringing up the file.
Okay.
Yes, sir.
Court calls CR 223646D, the state of Texas versus Ray Robert Sines. Can council please make their announcements for the record?
Allison Booth for the state.
Even McCram has some signs to my left.
Mr. Sines, can you raise your right hand? I swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, we're here today for a motion to adjudicate. Are you the same Ray Robert Sines who in CR 223646 pleaded to aggravated assault with a deadly weapon? Is that you?
Yes, sir.
And you were given 3 years deferred adjudication on that case?
Yes, sir.
Is that correct? Okay, we're here today on that motion to adjudicate. I'm showing you what is the state's motion to adjudicate in that case, and a packet with other papers, including the stipulation of evidence, the exhibit, and your waiver. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
All right. The first thing is the motion to adjudicate. Then we have the stipulation of evidence and the waiver. I'm going to start with the waiver. In this motion to adjudicate, you have the right to contest this motion. You have the right to remain silent during contesting that during a hearing. Your attorney has the right, or you have the right to have your attorney cross-examine any witnesses the state brings against you. And you have the right, you don't have the right to go in front of a jury on that, but you have all those others. Do you understand that you have those rights?
Yes, sir.
And understanding those rights, do you still wish to proceed with this agreement that you made with the state?
Yes, sir.
Okay. In addition, there is a stipulation of evidence. In that stipulation of evidence, I will use it to determine if there is sufficient or insufficient evidence to find that you violated your conditions of the probation in this aggravated assault case. Did you know that I would use that stipulation of evidence for that purpose?
Yes, sir.
All right. In this case, you have the right to know the evidence against you. Have you and your attorney gone over the evidence that makes up the basis for this state's motion to adjudicate?
Yes, sir.
And in this case, has your attorney provided you with effective assistance of counsel?
Yes, sir.
All right. According to the motion to adjudicate, before I go there, do you think that Mr. Sines is competent to enter into this plea agreement today?
Yes, I do.
Okay. And have you received all the evidence that you need in order to advise him on this case?
To the best of my knowledge, yes.
Very good. According to this motion to adjudicate, you will be revoked on the aggravated assault with a deadly weapon, and your agreement is for 20 years in the Texas Department of Criminal Justice. That will run concurrent with your other cases that you were sentenced on this morning. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge that you failed to obey all orders of the court and the community supervision officer, how do you plead, true or not true?
True.
To the charge that on or about the 30th day of September 2023, you were charged by the San Marcos Police Department for murder.
True.
Are you pleading true in both those cases because it is true and for no other reason?
Yes, sir.
Based on your plea true, based on stipulation of evidence, find that there is sufficient evidence to revoke your probation in CR 22-3646. It will be revoked and you will be sentenced to 20 years in the Texas Department of Criminal Justice. That will run concurrent with your other cases. Is there anything else we need to take up at this time?
Nothing from the state.
All right, sir, I followed your plea bargain agreement in this case, and for that reason, you do not have a right of appeal. I'm signing the trial court certification, and that will be added to your file. Anything else?
Those are just the judgments on his other counts, Judge, and I just need to know when you want to schedule allocution.
Okay. Anything else on the record?
Yeah, I can't do allocation this week.
Okay, let's just, anything else we need to take up on the record?
On this particular matter, no.
Okay, scheduling we can do off the record. Can you go off the record now? Just hold him over there for a minute, Steven, so we can figure this out.
Oh, yeah.
Let me write one more thing. Okay, what does it look like when we can do this?
I think Monday, the regularly scheduled trial date might work.
Yeah, if we could do it maybe after the jury's excused for lunch.
Yeah, are you gonna be here?
I'll be in the building. I gotta stop in Bear County first, but I'll be in the building that day. I'll be here by lunch for sure.
Okay. Well, then let's do it that time over lunch.
Monday at noon?
That's fine.
Yeah,
I'll
let's get 'em-
tell our family to be here at 11:30 in case you break early for.
Yeah. Sounds good. You were saying you weren't gonna be here on this Monday?
No, on Friday.
Oh, this
They were
Friday.
talking about maybe
Oh,
doing it Thursday or Friday.
Okay. All right.
Thank you.
Thank you, Ms. McCray.
I'll be here for the jury trial.
We just need to go back one more, please.
Jones.
Ms. Johnson, do you have anything else
He
you need?
brought a waiver.
Okay.
So
All
Jones
right.
should be done.
Good luck to you, ma'am.
It'd just be Kyle's guy in there for you.
Shreya, can you go downstairs and take a test, please? I think it will be through probation, right?
Correct. He's on supervision.
Is that Rios or Renteria?
Renteria Rios. It's two.
Okay, and then after you've done that, sir, if you will come back and go to the district court office, we'll tell you what the status is. Do we think Kyle's going to be here?
I don't know, Cindy called him after voicemail for him again.
Okay, so you'll go, we'll not be in here when you come back. So you'll go, after going to probation and taking your test, you must come back, go to the office so that we can give you the new date. Looks like your attorney's not going to be here today. And so we'll tell you the date that you need to come back. It's just, it says district court. All right. You need to.
No, he knows where to go.
He knows where to go.
Yeah.
Okay, is there anything else left on the docket?
Mo Brown with Unique Walker.
Oh. Did you hear from him?
No, his phone was turned off. I left him a voicemail on his cell phone.
Okay. What is the status of that case? I mean, what is it? What are we doing? Oh, that was a plea. State, can y'all please reach out to him? We'll call that one back on Monday at noon. Anything else left? All right. Thank you, probation.
Keeping a question for you. If we have stuff that needs to be signed, do you prefer us to present it at the bench or to drop it off at the window?
I mean, usually, probably the safest thing is through the window because then I'll get it.
Yes.
No one's here, so.
Right, I just didn't want
I'll
to
get 'em.
bring it up
Again,
here.
the only issue with that is if you're on the bench and then you finish court and leave for the day, it doesn't get signed that day. Sometimes there are urgent documents from probation.
Okay.
And they will contact me requesting your signature right away.
Yeah, I mean, if there's something you have right now, if there's something you want to take up, I'm happy to do it. I mean, generally, if we're not in court, then. go
This
through-
one's
I
pretty
mean, what
simple.
I wanted to say is that, for instance, you don't have to wait to see me in court. If you have something that you need, for instance, the next 2 days will be on the civil docket. If you just get it in through the window, then she'll get it to you. Anything, I don't think, any other cases unique will be redone. Rios will reset.
It's just a waiver of fees. He went to treatment, so we wanted to take those fees from him.
No, it literally will not let you do it.
This one.
Ruby, I think we're done. Hey, I think we're done. Thank y'all for your hard work today.
Thank you.
Thank you. Good to see you.
Signatures for some rights for that on Monday. I did this to you, Docket. Just in the mail.
Yeah.
Okay.
Yeah, you just want to grab it. Stuff that I got.
So do y'all have an objection to the person?
I'm sorry, I'm not privy to what they can get clarification and have it resubmitted. If it's a condition, we will tell them no, and because it's already noted.
Yeah, let me know what your recommendation
Okay,
is.
thank you. I'll do
Okay.
that.
No, it's yours, I sold.
You still have that exhibit?